Good morning and welcome to the third edition of Turnip Innovation Festival. Thank you for the enthusiastic response from the Indian academic and the startup ecosystems that has made Turnip Innovation Festival a truly big IPR focused event in India. What started as a pandemic experiment, it's now truly mainstream. During the last 2 years, there has been a significant push by the Government of India, by the Ministry of Education, and various accreditation bodies to create an atmosphere for IPR awareness within institutes. So much so that beyond IPR awareness and IPR creation, an important performance metric now for institutes is IPR commercialization. Hence, we have kept this year's theme as intellectual property commercialization. Even within the IP field, commercialization is a niche topic, and very few IP professionals truly work on the commercialization side. So we have gathered today to listen to some of the most eminent IP professionals in India on various topics related to IPR commercialization. With this, I will first invite Mr. Munish Sudan for his talk on winning the game of innovation. Munish Sudan heads the IP section of Global Tata Steel operations. He manages the patent, copyright, and design portfolios. He's also responsible for managing IP ownership, licensing, confidentiality, funding, and other contractual aspects of research and technology transfer. He's licensed to practice as a patent agent with the Indian Patent Office and holds a postgraduate diploma in IP law. He's also a certified licensing professional and a graduate from in business management from XLRI Jamshedpur, specializing in marketing and strategy. So with this, I invite Mr. Munish Sudan. Welcome to the stream, Munish. The stage is yours. Thanks a lot for being with us.
Thank you, Rahul. I'm just confirming. Am I audible? And I hope you're able to see me.
Yes, it's perfect.
Okay. So it would be great if you can just make my slides appear on the screen. Yeah, thank you. A very good morning to all of you. And thank you, Rahul, for inviting me again to this conclave. And I remember when I talked last time around this year, around this time only, I talked about what India lacks in terms of becoming the next economical power in the world. And we talked about that what we lack in Indian ecosystem is in terms of knowledge creation and knowledge exploitation. And at the end of talk, I got a lot of questions which were related to innovation strategy, and people were asking how to make sure that our efforts towards innovation becomes effective and they are getting utilized. And that's where I picked up this topic, the topic of winning the game of innovation. And I have used this metaphor of game intentionally, intentionally from the perspective that when we talk about any game, like any game, innovation has many similar aspects. Similar aspects like it goes through different phases. You need to be competitive to win any game, and at the same time, the challenges, as it happens in most of the games, are unseen. And more importantly, like a game is time bound, innovation is also time bound, and you need to understand the timing. That's very, very critical. So this is what I'm going to talk about, and this is what I have put up for today's discussion. We'll talk about what is this game all about, what are the important phases, and more importantly, we'll spend considerable time in understanding innovation strategy. And last but not least, what is the role of intellectual property in winning the game? So that's what I have put up for the show today. When we talk about game of innovation, essentially this game of innovation is taking an idea to commercialization stage, uh, conceptualizing something in the lab, and then taking to the market so that customers are ready to buy it. You need to create that appeal. You need to create that value proposition that customers want to buy it. And that's the stage we call as that we have reached to the innovation stage. If I further simplify it, what it needs to make that appeal, it needs that you need to have a value driven solution to the problems. and it's very, very important. The terms, when I've written value driven, people come up with solutions, and there are thousands and the millions of solutions you'll find from many problems, but those are not value driven. And what happens, because those are not value driven, they never get used. And hence it's very, very important to understand the value which is driven by the your solutions. And more importantly, there's another perspective which is on the problem. We need to have that knack of understanding the right problem. And when we talk about innovations, I don't think anybody on this earth can forget one of the greatest innovators that we have seen in 20th century, the Thomas Edison. And he put it very precisely. He keeps the utility at the forefront. He says, anything that won't sell, I don't want to invent. Its sale is proof of utility, and utility is success. Now the question comes, how to make sure that the solutions that we are coming up with, they're getting utilized by the customers. And that's where the first thing comes. And that first thing is about understanding the problems. And what I have seen based upon my own experience of last 2 decades, that people don't pick up the right problems. And when we talk about problems, the problems are typically of 2 types: what we call as the obvious and non-hidden, and a hidden or non-obvious problems. And what are these obvious and non-hidden problems? The problems which are very apparent, which, if you talk to your customers, the customer would easily tell you what they're looking for. It's like pain points which these people feel on a very regular basis. Now, delivering solution on this, of course, these are needed, and almost every company, every organizations work on this, because you can't keep your customers unhappy. If you're not working on this, of course, it means you don't take care of your customers. What I'm going to talk about is the hidden or non-obvious problems. Now, these problems, customers can't tell you, customers won't tell you, customers won't be able to tell to you, and that's where the real knack lies. And often when I talk about the hidden or non-obvious problems, I get reminded of a quote from Mr. Henry Ford, and he says, if I would have asked my customers what they would want, they would have said a faster horse. They would have never told that I need a car. Another very important example which I've seen in my lifetime is related to WhatsApp. No customers complained about internet messengers, but then somebody realized that there's a hidden problem with the customers, and that's how people came up with the WhatsApp. It's very, very important that we understand the gravity of the problems, and bigger is the problem, bigger is going to be impact of the innovation. So we need to be very, very clear when we are starting our innovation journey. We understand the right problem. And as Albert Einstein also says, if I were given 1 hour to save the planet, I would spend 59 minutes defining the problem and 1 minute resolving it. You need to understand problem in very, very minute details, because that's the primary thing, or that's the starting point for your innovation journey. And this game of innovation kicks once you have identified the right problem. And if you talk about the innovation process, the innovation journey, that's how it looks like. It starts with the problem, of course. But then once you have the problem, what you start doing? You start ideating. You start looking for ideas. How can I solve those problems? And these ideas are basically imaginary ideas, technical solutions, the innovative solution that you look around based upon basic scientific and technological principles. And then from ideation, then you zero down on few selected ideas which you want to pursue. And once you have zeroed on based upon certain metrics, I'm not going to talk about what are the selection criteria, how you can select. That's a different topic altogether. Once you have reached to the selection stage, then you move to your acquisition journey. And acquisition journey is actually, now once you have ideas which you want to pursue, you want to have the real-time solutions. Very, very important, because ideas on paper, you have to convert those ideas into real-time solutions. And that's where you start your journey. You start your research and technology journey, research and development journey. And of course, once you reach there, then you move to the exploitation stage. You commercialize that. That's the stage which we call as we have reached the ultimate goal of commercialization, once you are able to sell your invention. Okay, so this is the typical process which any innovation journey would follow. Now, the basic question around the innovation strategy lies around that how you are able to create, deliver, and capture value. That's the first fundamental question you need to answer. And the second fundamental question you need to answer is, suppose we have created that value, how are we going to retain and protect that value? How we are going to have that sustainable competitive edge? And that's where the role of intellectual property comes in. And we'll talk at length about both of these things. So you need to have clarity on these two very basic questions when you start your innovation journey. Once you have moved from ideation, selection, and once you have zeroed down on your acquisition path, once you have zeroed down that this is the path which I'm going to take, you need to question whether that chosen path is able to create, deliver, and capture value. And second, if that value you are able to retain and sustain. And that's where the role of intellectual property comes. We'll talk at length both of these. Now, when we talk about answering the first question, how will we create, deliver, and capture value? I'm just putting up a figure which I picked up from a very famous book, Edison in the Boardroom, and I would refer and recommend all of the innovators to go through this book. It's one of the best books written on intellectual property strategy. And this figure actually tells that less than 5% of IP in a portfolio is actually directly utilized. And I'll give you another figure. Worldwide, the statistics is that not more than 10% of the new product developments are successful. So the success rate is less than 10%. Now, what happens with those new product developments? What happens with these portfolios, which is 90% which gets unutilized? And when we talk about IP portfolio, patent portfolio, of course, we need to understand that if you're talking about a successful patent portfolio, means all those 90% portfolio had element of novelty, and so is case with the new product development, because that's what we call as a new product development. And when I have a brainstorm around this, I have deliberated, debated with my fraternity, with my ecosystem around, I've found very revealing observations. And these revealing observations, which I've listed, the first and foremost is the age-old creativity has been, too much around novelty, and focus less on value. Okay, but we need to understand that it's the value which is perceived, it's the value for which customers pay. It's not for the novelty. Okay. And we have overhyped the novelty. It's essential, of course, when we talk about innovations, but novelty without value has no consideration or at all in innovation process. And that's where we need to have a very deep dive in terms of understanding when we are coming up with any chosen path that we want to pursue. And what is that? That if is our chosen path is valuable or not. And what happens most of the time, people are so much fascinated by the novelty. And it happens most with the researchers and technologists. Okay, they when they find something exciting, they go all out, they pursue it. Of course, that's very necessary to pursue, to have that persuasion. But without giving a consideration, if that novelty is backed up by the value, is customer going to accept that value proposition which I'm going to propose? That's very, very essential. And hence I say innovation is essentially about creating new values. Okay, so novelty lies in new values. Novelty, if only you are saying from the perspective of getting a new path discovered, getting a new API discovered, coming up with a new process steps, coming up without any value consideration, it's not going to be used by the customers. So very, very fundamental, very, very important that we need to bear in our mind. The second very, very important aspect that we need to understand, that value is relative and a contextual concept. And hence, it's very important we understand what are the key prevalent trends in our domain. I'll give you one example. Today, if you come up with a phone which gives you maybe a 5 MB of extra storage, it's not going to excite the customers. Even you come up with a 1 GB or 2 GB. But if you talk 15 years back when the smartphones were launched, the mobile storage was one big value proposition which was adopted by the mobile players. For one extra GB, for 15 GBs, you were able to charge extra for that. But that value is gone now because it has reached to the saturation level and it doesn't excite customers more. So is case with the cameras also. You come up with an extra 5 pixels, it's not going to excite. But if you look back 15 years back, you would understand and appreciate that extra pixel in your camera would be was in a position to get extra value for the manufacturer. So it's very, very important to understand that when we are taking a path, or when we are starting an innovation journey and we have taken a path, we understand that value that we are proposing, where does it stand vis-a-vis our competition, vis-a-vis existing value proposition. That's very, very important. And then assess it whether it's going to fetch value or not. So value is again perceived by the customer. It's not what we think. And that can only happen when we understand the competitive landscape nicely, diligently, and comprehensively. Very, very essential. And for doing so, it's also important that you understand what kind of organization you are. And I know I might be talking to a lot of technologists and the young innovators. And when I talk about researchers and technologists, of course, this is the first kind of organization you are first to the market. You need to be R intensive, research intensive. But there are many organizations which will believe in another philosophies, follow the leader, application engineers, me too. All those are relevant. The innovation opportunities relies and revolves around all these four type of categories. But you need to make that assessment, what kind of innovation effort you are going to put in. And if you are going to be R type, you need to understand the journey of or R type of innovation. And as it happens, technology readiness skills that people refer most often, you need to understand how a typical innovation journey looks like. And you need to also appreciate that there would be a phase, what we call as a valley of death, where most of the invention actually die out. They don't reach to the innovation stage, primarily because this is the time where you need a lot of funds to scale up your invention, to develop your prototype, to come up with the demonstrations. And you need to prepare for this well in advance if you are on a journey of our type of organization. And you also need to understand and appreciate that this valley of death is more pertinent, it's more considerate for hardware type of innovations, not for software innovations. They don't need a lot of funds. If you come up with an app, if you have a good value propositions, you don't need a huge investment in terms of putting up a demonstration plant, proving your technology. And that's where you need to prepare well in advance. You need to create that value proposition. You need to create those results so that when you approach for funding from industrial organization, when you approach for funding from the investors, you are able to tackle this valley of death phase. And if you survive this, your probability of success definitely increases, because this is the phase which is the most cumbersome in innovation journey when we talk about the research intensive organizations. The another very, very important aspect is timing the innovation. So you should not be, and you don't need to be too early or too late. If you're too late, you have missed the bus. So you would become another me too. Even you believe that you're our type of organization. And if you're too early, it means that actually the ecosystem is not ready for you to adopt that. I'll give you example of IoT. People nowadays talk about, there's a buzzword about IoT and artificial intelligence. Artificial intelligence, deep learning, all these concepts were there for quite some time. Even the basic principles, everything was lying around. What was missing? We had issues with the high internet speed. We had issue with the high storage. So now all those things have been taken care, and that's why we are talking about there's a verge around. Everyone is talking about that. We need to talk about artificial intelligence, high-end data analytics, because the ecosystem is ready now to adopt those kind of innovations. So you need to be very clear. A very simple and straightforward examples I would give: the digital payments and many of the work from home technologies become so adapted primarily because of the COVID implications. Okay, so you need to understand, appreciate, to time your innovation. That's very, very critical. And as it happens, the Gartner hype curve, this is a very famous curve. It says that every technology domains goes through a peak of inflated expectation. You see a lot of news around that, then it goes to trough of disillusionment, where you people start realizing the reality, and then actually the slope of enlightenment happens, where people start coming with real time solutions, and then the plateau of productivity comes. Now, ideally, as it says in the stock market, you can't time the market. I say the same thing for the innovation also. It's very difficult to understand that what is that right time. Is it during the peak of inflated expectations, during the plateau of productivity? But uh, if you understand and assess the situation well, I think somewhere around trough of disillusionment and the slope of enlightenment is the right time for your domain, where you need to start and pick up and maybe press the accelerator, because that's a time you will see that adaptability of your innovations become more and more clearer, more and more pertinent. Another very important aspect that you need to understand to make your innovation journey success is the diffusion of innovation. And this theory actually says that any innovation, any new idea is actually adapted across the population in certain way. And this the propagator of this theory has actually divided the whole population into different categories. The innovators who want to try new things, and that's true not for only the consumer related inventions, but that's true also for the industrial innovations also. There would be early adopters, and then there would be a main majority, and then there would be main maturity, mature, and then late adopters and laggards. To make your innovation success and call it as a success, you need to target the main majority early. If that's a tipping point for you, if you reach that, then there's no stopping. But all your assumptions should be based upon this: what is that size of main majority for my innovation? And if that is the size that I need to target minimally, what is the economy of scale that I need to look at? All these assumptions are very, very important for you, and that's why I say your assumptions need to be well thought out. They need to be very comprehensive, backed up by the data. Uh, and once you are clearer on this, that you and we try to answer the first question, that creating the value, delivering the value, and capturing a value. I'm not going to touch upon a lot of things on capturing the value and the delivering the value. There are different ways, but suppose we have figured out that this is the value that we want to cover. We need to be very clear about that. We don't need to be get hyped by the novelty only. We need to have more emphasis on the value proposition. The second is very important, is that we need to understand that there's a valley of death if we are research intensive, and that's the time, if we are related to hardware innovation, that's the time we would need funding, and we need to be well prepared to survive that phase. We need to time the innovation well. That's very important, and for that we need to have understanding where are we. And third, very important here, is that we need to have understanding about our competitive landscape, and that's essential primarily to know that how my value proposition stands vis-a-vis with my competition. Now, having clarity on this, the second very important thing happens is that how you are able to sustain that competitive edge. Suppose you came up with that solution. So now the question comes, are you in a position to leverage that competitive advantage? And that's where intellectual property comes. So intellectual property, the role of intellectual property is actually essentially a tool to protect your competitive edge. Okay. But again, the starking revelation which I have made based upon my experience, that only handful of innovations are able to leverage the IP advantages. And why it happens? The first and foremost is that IP is not considered during the innovation design stage. So what it means, when you're trying to figure out what is going to be your value proposition, you are not considering that how you are able to, or how would you be able to protect it through IP protection. The second is poor appropriability regime. We need to also understand IP is not this design. IP was designed holistically to cover all ranges of innovations when IP Acts were designed. So there are few technology, we have few domains where appropriability regime, the enforcement regime is very strong, but there are few where it's very poor. Understanding that is very, very important. And the third very, very important aspect related to how you leverage the IP based advantage is that people always consider IP is equal to patent. That's not correct. Okay, IP is more than patents, and you need to have that understanding. I'll touch upon this shortly. And when I talk about the appropriability regime and how you are able to leverage that, we need to also understand that every innovation needs the complementary assets also. And few complementary assets are freely available, few are tightly held. Uh, and understanding about these complementary assets which are needed for exploitation of innovation is very, very necessary to understand what is your position. And I'm just giving you an example of software related innovations. You hardly need a lot of complementary assets. These are not tightly held. Okay, it's easy to make your app popular, make your dashboard popular, make your platform popular. But when we talk about hardware-related innovations, you need a lot of complementary resources. Maybe you need a manufacturing capabilities, you need to have distribution channels, and you need to understand how strongly these complementary assets are held. Are these freely available? Are these tightly held? And then you need to combine it with the appropriability regimes. That's very important. And if your appropriability regime in domains in which you are pursuing your innovation journey is strong, and complementary sets are also tightly held, you can dominate. And you do need to have access of those complementary assets, of course, to dominate the market. But suppose these are not freely available and appropriability regime is also weak, it's very difficult to make profit because you will have very crowded competition. Every now and then person would be able to imitate what you are trying to deliver in the market. And given that the complementary resources are easily available, you don't have a control on that also. Okay, so there are many examples which would fit in this the four quadrants category. We need to understand where do we fit in, and then accordingly take and decide whether we should pursue that path or we should change our innovation strategy. Another perspective which is very important why people are not able to succeed on innovation journey, again because having patent is not enough, having an IP is not enough. And IP you can get once you satisfy the criteria of novelty and inventiveness. But suppose that novelty and inventiveness is not creating any new value, is not capturing that new value, is not covering any new value, that patent would remain in the shelves. It's not going to be used by anybody. And then we also need to understand that IP alone is not sufficient. It's IP along with value is sufficient. That's the whole point. And IP is not patents. IP just not patents. It's much more than that. I'll give you one example. If you're talking about industrial technologies, from concept to commercialization stage, you will see there's a trend of decreasing patent share as you move towards the upscaling, but the know-how share increases, the tacit knowledge increases. You need to understand and appreciate that this tacit knowledge is very, very critical if you want to sustain your competitive edge in the market. How you sustain, how you protect that tacit knowledge, know-how is going to be a key determinant for your success. Another very, very important aspect is related to trademark and the branding. Okay. And let me just tell you, IP power of many innovation is reflected after IP expiry. Many times people come up with the formulations, they come up with a very good brand, and as it happens, the patent expires, these become open for people, but people still go for the original one. Why? People develop an association. IP helps you in developing that association for long-term exploitation. And that can only happen when you understand branding, when you understand that trademark is very, very important. Like it happens that switching cost in OEMs is difficult. There's a stickiness in consumer products also. So people need to think like when somebody had come up with a toothpaste, people still call toothpaste as a Colgate. Why Colgate could develop that association At one point of time, that formulation might have been patent protected, but now that formulation is freely available. In spite of that, if people have developed that stickiness of using Colgate, people would still go for Colgate. Even that similar formulation is available. So happens with the pharmaceutical drugs also. Okay. So we need to understand that there's many other aspects of IP which are very, very important to maintain, create, and sustain that competitive edge. And that's where the crux of the game lies, that you need to know that how we can reach to the center. And to reach to the center, you have multiple obstacles. Okay, and what is this center? This talks about that when you're looking for solutions, your solutions need to be valuable, and along with valuable, if they can be patented, then you have win the game. Means you have something which is accepted by the customers, you have something for which competition can be kept away because you have IP protection around that. Okay, and that's the innovation game. That's the game that we have to win. And how does this game starts? This game starts with that you have problems and you come up with the ideas, and then ideas you start looking for the solutions becomes inventions. Not all inventions become accepted by the customers, only few become accepted by the customers, and those become the innovations. And again, all the inventions are not patentable inventions, only few inventions become patentable inventions. And that's the game lies at the center. You have the inventions which are acceptable by the customers, those become the patentable innovation, and that's where the game lies. That's where the success lies. If you reach there, you have found the gold mine. So key question, if I have to sum up my talk, I would say when you're starting your innovation journey, you need to think through, are you creating value or creating novelty? Very, very important. And as it happens, it's underlying value which is critical for the customers. And the second is, can you protect your competitive value proposition? And that's where the IP protection comes. It's very, very important to understand this. And let me just tell you the single most reason why innovation efforts, or why innovation efforts fail. And they fail primarily because there's a gap in terms of understanding what customer is wanting, what customer values, and what we deliver to the customers. And primarily, again, happens, this gap in understanding happens because we overhype novelty and we don't give much consideration to the value proposition. And why that happens? Again, the reason for that is that many times we are biased for our opinions, for our paths, and we don't see those paths from multiple lenses. So you need to back up your assumptions through multiple lenses. You need to test through before you start your innovation journey. So with this, I would take a pause, and I would be happy if you people have any questions for me. Rahul, I'm not able to listen to you.
Yeah, there was a question earlier. I am unable to find it actually now, but it was about when do you consider a innovation to be complete, so that you can claim it.
Uh,
Who was
I
asking
could not
this?
get your question, Rahul.
Yeah. When is an innovation considered complete? How do you know it's
Ah,
complete that you can
yeah.
claim it?
So, yeah. So, very good question, and that's where I was saying. You come up with something, and suppose one customer buys it, you can't say it's a successful one, and that's where I'm saying you need to target at least the early majority. And early majority, I mean, if the mass size of a particular domain or a particular innovation is 100, you need to touch that minimum early majority mark to call it as a successful one. And that's where you also need to make in assumptions that what is the economy of scale that you would need to touch upon that early majority.
Yeah, we have one more question from Satyaraju. How to decide when to stop maintaining a patent
Yeah.
granted to universities?
Yeah, very relevant questions. As it happens, Vijay, uh, what happens is that many times we are not able to understand whether what we have created is valuable or not. Okay. And sometimes we create, and it happens, as I says, 90% of the IP portfolio remains unutilized. So what could be the reason? The first reason could be that we have created something nobody is wanting. Okay. Or the second reason could also be that we have created something but it doesn't reach to the right audience. So you need to do your customer mapping well, that if I have created something, who could be potential customers, and then you try to make that reach to those customers and understand what is their viewpoint. As it happens, we go with a single mindset, what we like, or we are so much fascinated by the novelty, we don't understand why this is not going to be valuable for end customers, whether it's an industrial innovation or whether it's a consumer related innovation. And that's where you need to have a lot of understanding. You need to reach out to the right customers, have that Q&A sessions. What are they wanting? Why this is not good? What can we do to make it better so that you would be ready to accept it? So those are very pertinent strategies that you need to follow. Just because we have decided this is what we will do, we get blindfolded.
Yeah. One more question by Dr. Swati Joshi. How to identify the problem in market? Probably similar to this answer.
Yeah, so yeah, that's the key lies with the understanding. Lack of understanding problems in art. It as it happens, the trivial problems everybody knows. Okay, as it happens now, if you go and want to buy a car and somebody doesn't give you a power steering, you will say, "Oh, I didn't need a power steering; it's a given." But what is that needed to the next level of innovation in steering? This is where the imagination lies. So the typical strategy, of course, maybe next time sometimes I can come up with a session on ideation, that how to imagine and come up with the scenarios which are possible. So what you do in such a cases, you come up with the scenarios, that I'll come up with solutions, and once you come up with those solutions, imagine solutions, you reach out to the customers to understand that value proposition, that is it exciting my customers if I come up with that level of value proposition. And you validate that through multiple lenses. So not just reaching out to one customer, one industrial organization, or two. You need to re-articulate your question, you need to re-articulate your value proposition and take that customer's feedback before you start your innovation journey. That's why I'm saying design your innovation journey. That's very important. And designing the innovation journey is essentially talking about understanding the value which would excite the customers. The second, how you would be able to protect that value.
Yeah. Is commercialization necessary for successful innovation? Dr. Vikram Singh Chauhan.
So, doc,
Uh,
yeah. So, I think commercialization is integral part of innovation. You will not
Integral
call
part.
anything innovation if it's not commercialized, if it's not used. And definition of commercialization, of course, varies industry to industry. Innovation is all about that, and you have created something, it's getting used. That's simple. Okay. If you have created something, it's lying in papers and patents. That's not what we call as innovation. You can call it as invention.
Yeah, maybe one more question before I think Dr. Hemang Shah, he's here, and within 2-3 minutes we can start his presentation. Can we commercialize, Dr. Paramasivam, question, can we
Yeah.
commercialize patentable idea before grant?
Yes, we can do that, Dr. Paramasivam, but you need to do freedom to operate. You make sure that what you have come up with, it's not infringing on somebody's existing intellectual property. But uh, most of the journey starts once you protect. People start their innovation journey. So you can commercialize that, provided you have freedom to operate. Grant may take time.
All right. I hope that we can continue the questions in the next talk. For this talk, we are. If you want, Munish, you can take maybe 1 or 2 more questions by the time that Hemang is adding his slides. Uh, let's see.
I would be happy to answer your pending questions. You can connect me on LinkedIn or through Rahul, and I'd be
Mhm.
happy to answer any question which remain unanswered.
All right, great. Munish sir, thank you so much for your time, and very, very grateful for this relevant. The first thing about commercialization, people think, after IP, how to commercialize. But I think the first thing is just to build for commercialization. And I think that it's a very natural and very good extension to the next talk, because Dr. Hemang Shah, he talks specifically about how do you basically decide what to do research on, and elaborate more on that. So thank you, Munish. Have a great day, and we are around. It's a small community, so we will connect again.
Thank you. Thank you, everyone. Have a great day ahead.
So, folks, I request everyone in the chat not to write your institute name in the chat box in the live stream, because it hides the comments which are relevant questions. So please make a note of that. Let the questions which are relevant, because some of them are getting hidden because of so many people writing their institute name. So please, there is no need. We are not marking your attendance of any sort. You can claim your certificate by filling the feedback form after the event, and yeah, so no need to write your institute name in the live chat. Do ask questions and relevant questions from time to time. We will take those questions. So with this, I would like to introduce our next speaker, Dr. Hemang Shah. He's the engineering director of Qualcomm India, and he has over 15 years experience in strategy and innovation. He collaborates with startups in India to develop products that are using AI and uh, advanced cutting edge products. He also provides business advice regarding IP strategies. He also owns two US patents, and he has more than 10 patents pending with US and international patent offices. He has been an academic, and currently he writes on innovation. He has a very famous Innovation Sports Life innovation newsletter. So Hemang Shah is going to continue our discussion on selecting research products that are good for tech transfer. So welcome to the stream, Hemang. Really great to have you again, and yeah, the stage is yours.
Thank you, Rahul, for firstly organizing this Turnip Innovation Fest. Uh, and this is a great, I guess, discussion that we had from Manish just a bit earlier. So again, Manish, knowing him, always, provides something which is worth thinking about. And again, thank you all. Great to see so many of you join here this morning. So today, I'm going to talk about how to select research projects for tech transfer and commercialization. Right. So here, the goal is to sort of inspire you with a few things that allow you to consider. You may be focused on a few projects, and but which ones do you take further ahead from the view of not just doing research or fundamental research for the sake of publishing, but if you want to take that research work and convert that into products, if you want to work with the industry and try to see if they can absorb your work, how should you think about selecting these projects in the first place? And why does this selection matter? Because I believe that a problem well defined is already half solved. Meaning, if you chose the right problem, then the solution, like the choosing the right problem is 50% of the solution, right? So whatever outcome that you need afterwards, all that has a better chance of succeeding, particularly from a commercialization sense. So let us dive in. The framework I'm going to share with you is based on this concept called as three design challenges. Now, I apply these three design challenges to select something that you would call as an innovation, or the identification of an innovative product, right? What will constitute something that will give you a wow experience to someone? So this discussion today is going to be based on these three design challenges, but adapted for choosing a research project. And this framework, in some sense, is quite simple. There are three primary criteria you need to look at, and I call that criteria as people, technical, and business, and strictly in that order. So first, we'll look at the people segment. Then we'll understand what the technical segment focuses on, and then we'll determine if there is any business potential. Only if you meet those three challenges should you embark further on that journey. The people segment tries to look if we are addressing a real customer need. Okay, now a customer here is very different for a research project, and it's very different for a real world product. So if I have a pen in my hand and I'm trying to introduce that new product, I need to know that who are my customers, because there are already so many pens out in the market, right? But I might be looking at a very funky pen. Maybe it's a digital pen. Maybe it's a pen which can write on our phones, on our tablets, and it can also write well on actual books and paper. Now, it is my duty to understand firstly whether the people want that product or not, right? So how do I go about that? And for most projects which are around, or most product development focuses on understanding the users, right? You want to talk to them, you want to understand what their world is like, you want to understand what are the big pain points that they are trying to solve. So you're trying to get a bank of information around what problems people are facing. You're also compiling what is the size of this population. Is it one person? Is it just teenagers? Is it just people in certain geographical locations, and so on? But for a research project, we need to ask the same questions a bit differently. The first step out here, like I'm sure all of you do, is to conduct literature search. But I suggest you do this in phases. And the phases I recommend are low, medium, and heavy or high. So in low, what I'm trying to convey is that you focus on some cursory uh, literature search process. Like try to read white papers. White papers give you information which are a bit broader. They're not as detailed as a journal paper, and you don't need that kind of rigor at this particular stage. You're trying to read industry reports here in the low phase. So the intention here is that you're trying to get some sense of the status in that particular domain. Once you are a bit satisfied, you know that hey, there is some potential here which I, or there's some opportunity for me to explore further, then you dive a bit deeper, and that's when you maybe start reading, I would say journal papers, but I would call them as review papers. Review papers are of course a lot more detailed compared to white papers, but they they have an understanding, or they provide you an understanding of what that overall research landscape covers, right? So you first confirm your analysis over there, that hey, your white papers give you some idea on here is something for me to go after. You confirm that a bit in the medium phase, and then once you are really sure that hey, I think I'm onto something, that's when you dive further deeper, and this is when you actually start diving into individual research papers. And that direction for that comes from the review papers, because a review paper give you information in a bit wider scape, a wider landscape, and then from that you are cherry picking in kind of in which direction to go further. The analogy I'll give you is that, like, if you were to drill an oil well today, what would you do? So in the low phase, which is you're trying to familiarize yourself with the industry, you're trying to look at satellite information, you're trying to look at, I'd say, geographical maps and all that, and then you start narrowing down. Maybe you try to understand what the ground's status is. Maybe you hone in on a country or a specific state, maybe even a specific district, and then where exactly to drill into, right? So that's your heavy or high literature search phase. Now in all these phases, what you're trying to do is the step number 2, which is you're trying to record unanswered questions. So any point of time you see that something is not explained to your satisfaction, and there are times when people say we are observing this phenomena, we don't fully understand it. So you're trying to record such observations because these are the areas to drill further into. These are the questions worth answering. But are they really worth answering? That's the phase where you try to determine how critical these are to the scientific community. Because your primary goal for research is to advance the science. The commercialization is the next step. But at least let's take care of the primary first. Now, the problems which are critical to the scientific community, it's ultra important to highlight them. And those are the ones that will lead to, for example, it can be a PhD research topic, or it can be an MTech topic, right? So after you've done that, you confirm with the industry acquaintances whether the industry also cares for these unanswered questions. Does the industry see potential? So if you were to solve those questions, or if you were to give them this next level of understanding, or this next level of process that you've developed, this next algorithm that you develop, can the industry use that or not? So I'm going to pause here. I'm going to see if you have any questions, if you have any comments, on this particular segment. And I'm reading the, I guess, the live chat. So feel free to type in. Okay, so I'll just recap here. So in the people segment for our research project identification, we're going to conduct our literature search in phases: low, medium, and high. From that, we'll record unanswered questions or unexplained observations. Basically, we're trying to find something which is worth probing further. Now, before we actually probe them, we are going to determine how critical those questions, those observations are to the scientific community. Separately, we'll also confirm with our industry colleagues, with the people that we want to do tech transfer to. We're going to confirm if they will benefit from these unanswered questions or unobserved or unexplained observations. So Balagopi asked, finding the right customer, is it we converge? So I'm not sure if I follow your question, but the customer in this case, for a research project, primary customer is your scientific community, are the other researchers, and your I guess another secondary customer is your industry, right? Are your those industry colleagues need to know whether they can absorb your work and go further with it. Ridyesh asked whether we need to check for the problems of people for doing research. Yes, Ridyesh, we do that, and instead of talking to individual people, what we'll do is we'll determine that in the literature search phases. So any journal papers, so in the low phase, you're starting from white papers, and white papers are generally written by industry experts. We try to look at industry journal research reports. If they are publishing something, that is an indirect proof that people are interested in that particular research area. Next, when you go to the medium phase, you look at uh, at what I would call as an industry research report or a research review paper that tells you whether the research community cares for that topic also or not, right? And then by the time you reach the next phase, you are very sure of diving further. Next question I'll focus on is by Selva Kumar, that what do we have to do in the determine section? So in the determination phase, what you're trying to do is the unanswered questions which you spotted from your journey, the opportunities which you spotted. You try to talk to your colleagues in the scientific community. So this, what I would do is I would talk to the professors. I would ask them that I could I could solve these, let's say, three questions. Which ones should I solve further? And collect the observations from the professor. Similarly, if you have access to, in those journal papers, you would have seen the authors. Try to have conversation with those authors. because quite likely they might be working on that anyway. But it's just good to have an understanding from them. If possible, attend conferences. Like there are industry society chapters, there are engineering chapters, for example. If you can find the local meetings, you try to attend those and talk to the scientists, talk to the engineers, talk to the researchers in those communities. Discuss what your ideas are with them, and the minute that they tell you, you know what, that's an interesting problem, that is something worth solving, that's when you know you're on the right track. I'll focus on Darbha's question, which is the message, which is we identify market research and integrate with other literature search methods and do a customer survey before starting a good translatable project. So, Darbha, what we are doing here is we'll start with the market research, which is in the low phase. So, hopefully, white papers will also convey that same information. We will integrate with the other traditional literature search methods, which is the medium and the heavy phases. The customer survey here may not be fully required, because a customer survey for me is when I'm launching a finished product into the market. But here, the question we are trying to solve is whether a research project is worth undertaking or not. Right? So I won't necessarily do a customer survey right now. I'll do that afterwards. Okay, and Mrs. Didi Dokate asks, can we follow review papers as literature for our research? Yes, that is in the medium phase. Okay, so I'm going to take more questions later on, but let's move on to the next section, which is the technical section. So to recap, what we did in the people segment is we determined if something was worth addressing further or not. Now meaning we haven't actually solved anything. We have just identified whether a question is worth answering. Right? You've identified a problem statement. The solution part comes now. And that's what we'll do in the technical segment. That when you solve it, right, assuming that you do, is your solution going to be better than what exists today? So if you're going to be exploring, let's say, a new experimental method for a process, what do you expect as the outcome? Will that method give you much better performance than the approaches being followed today? Can you result in a finished output that is, for example, stronger than what is there today? If you're going to be working, let's say, on an algorithm, is that algorithm going to give you a better accuracy? Is it going to solve the problem in lesser time? So you're trying to identify which metrics are the key ones that you will improve on. But there are more nuances to it. But what are those? Now, quite likely in the people segment, you converge on an area that this area is worth solving. Now, instead of solving area wise, so in the technical segment, you're actually going to start drilling the hole to ultimately land oil, right? So you have to focus on one point. Where are you going to probe? So you have to pick one key problem to address. Okay, so from whatever observations you have to narrow down on, this is the key problem that I will address, and that problem has been validated by your scientific colleagues, by your industry colleagues. Next, you plan the solution in phases. Again, we'll plan this in low, medium, and high. We start with low, and here the idea first is that instead of actually getting things together to solve it, we'll try to whiteboard it. We'll try to go with a block diagram. Can I even set up a pen and paper solution in the first place? Meaning, not in reality, can I just determine the broad steps which are required to solve? So I get a landscape to go after, and then I'll dive a bit deeper into those, which is how do I get the different building blocks for that? Do I need to order some things? Do I uh, need to have access to certain facilities to solve it, and so on? And then the final step is the high phase, I call it, is the actual nitty-gritties, right? You might be coding in some cases, you might be running experiments in a lab in some cases, and so on. In the determined state over here, you will try to understand what is the performance impact. You'll focus on the metrics that could be, uh, what are the output that you will generate. It could be metrics based on that, or it could be a metrics of the process itself. That are you going to converge in a much faster state? Are you going to take lesser resources to do it? Are you going to optimize the performance? Right? Are you going to result in a solution which is scalable? Right? So you will determine the performance impact. But alongside that, it's also important to know that ultimately people or different technologies will be required to enable that in the first place. So what is the skill level required? Can I do it? And if you cannot do it, can your team members do it? What kind of education background will they need? And if they don't have those skills, can they be taught to them? Will you need to arrange for some master classes from either the research or the scientific community? Will you need them to go through some training in a dedicated lab? Right. So try to understand what is the skill development that you need to do before you embark on that journey. And of course, the equipment which is required, the kind of facilities which you need to enable those solutions. And the selection for that is always going to be based on the one that is going to give you a significant technical advantage. And again, the what is significant, you have to look at both the scientific community for your core research project and to the industry if you're thinking from a tech transfer perspective. So to the industry, you may want to ask that what kind of a performance benefit will you look in before you consider this thing. Because what happens is a and this is where even I was naive as a graduate student, that we would focus on a new way of doing things. And this was in the polymer industry, and we're like, hey, here's a new process that we've come up with. But that process was not easily transferable to the industry, because the industry was set using certain equipment. The industry was also using certain tools, and so they would have to change things significantly before they could adopt our approach. And so that amount of change was not fully digestible for them. So although our research approach did have significant advantages from a scientific perspective, but for the industry it was not fully ready. So that selection becomes critical. So I'm going to again pause here, see if you have any questions. Looks like this part is well understood. So I'll move on to the next segment, but think about these things and feel free to always type in the chat box. The last segment, and this is where I would say you need a lot more contribution from your industry colleagues, is the business aspect. That is there a viable business model that you can generate with your approach? Now, what are the steps that you follow to understand this thing? So work with your industry colleagues, and if you don't have a ready industry partner right now, maybe find a friend who is, let's say, from the College of Business, or someone who has done an MBA, or a or someone maybe ideally who is in the tech transfer domain. You want to bring this person into the mix, and get the next level of understanding. And what is this understanding? That what is required to absorb that technology. So if the industry were to take it, so in the example I gave you, that we have a polymer process, and now I want to explore that with the plastics industry. What overhaul do they need to do at their end? Can they absorb it right away? Does it fit with the existing machinery that they have? Do they need to invest in some new equipment before they absorb it? Will they need to change basically a lot of things at their end, or will it be readily absorbable? Something which is ready to absorb, is of course preferred. Now, assuming that they have adopted this approach, which I've been discussing with them, how much time will it take for them, before they start seeing results? Will they have to stop their existing processes, or can it run in parallel? And if their operations are stopped, how much time before they start seeing the results? But very likely, something which runs just for one time, it's very unlikely that it will be perfect. You will have to iterate, you will have to optimize it, you will look at the finished product, and then you might say that no, it needs further improvement, it's not fully ready before I can give it into the market, before I can launch a consumer product with it. So that time to market can be longer, right? So what level of iterations you would need to do? And your time translates into money, because it's not just the time taken to run those experiments. That industry partner will have to maybe hire a few people who are dedicated just for that effort. If they have to buy new equipment, they'll have to understand the total costs which are required. There may be certifications that they may have to go through. If it's a legal thing, they may need legal permissions. Like if it's a medical technology product, they may need some certification from the relevant councils. So all those factors need to be understood, both from a time perspective and from a cost perspective. You're in the business segment, translate everything into cost ultimately. And how do you know if that is going to be worth it or not? You use financial models. And once you use these models, there are different ones, such as net present value, meaning what you do is you say that over 10 years of time, these are the overall cost which you have to incur, overall investment that you'll have to do. But alongside that, here is the revenue potential that you will also observe. And so over a 10 years period of time, what is the net present value of doing that activity today? And if that is going to be worth it, you can say that fine, this is something that we can undertake. And quite often what tends to happen is that in this phase, once you start putting in the rupees and the time taken all together, you may say that this approach may be too time intensive, maybe it can cost a whole lot of investment, but the returns are not there for the taking. The customer is not ready for this yet, or the market size may be too small, right? So it's okay to come out of this project and say, we will not explore this as a business. But if your other two criteria are okay, which is the people segment and the technical segment, meaning if you are convinced from a literature search perspective, if you are convinced from your technical solution perspective, it could still be an impactful research project. It may not be commercialized, and that's okay. Okay, so that's one important thing to keep in mind. However, if you met this challenge as well, then you can be very confident that here is something that you can explore as a tech transfer opportunity. So this is where, if this thing worked, I would work with let's say a tech transfer organization, or maybe I would work with different firms that can help me commercialize this. Okay, so to recap, what are these three design challenges? So, in the people segment, we try to understand if the opportunity was real. We did this using firstly industry reports through market surveys. We try to understand the customer base here. And here, our analogy for the customer is the scientific community. Right? Are they really looking for this unanswered question? Because you are noting down any opportunities for you to further investigate from a research perspective. Is it just you who's interested in it, or are there other researchers, maybe other industry professionals who are interested in that need? So you're validating whether there's a real unmet need. At the end of the people segment, you basically identified a few problems worth solving. In the technical segment, you're trying to understand the impact of those problems if you solve them. If you solve it, compared to what exists today, compared to other competing approaches or other competing products, what is the performance of your approach? Is it 10x more? Or do you improve on the process side? Do you improve on the product side? You also want to answer if you have the necessary skill set. If you, your team, your company, or your research group may need training, you have to enable for those things. And if you may need, it helps to identify, will you need other equipment, other facilities to help you deliver it. The third challenge that we're going to address is the business segment. Basically, financially, is it going to be worth it? Considering the cost required to enable this, considering the time investment, is it going to be worth it, for you to address this opportunity? If you meet these three challenges, you would be very confident of excuse me, of a research project that can be commercialized. But if you have answered successfully on the people and on the technical segment, but on the business segment, you may determine that the market is not ready for this right now, it is still an impactful research project, in my opinion. So I'm going to answer, I see some questions in the chat box. And Preeti asked an important question, that is it advisable or do you need to sign an NDA before you reveal that with an industry colleague or expert? So Preeti, my suggestion is yes, it always helps to do it. However, it may not be realistic always to have an NDA because your industry colleague would be listening to many ideas, and you may choose to again explore this discussion in different levels. So if you explore it at a very high level where you're not divulging the core details, but if you're just asking their opinion about the importance of a problem, or whether that particular area is worth exploring, you may not need an NDA. But yes, when you're trying to or if you get into a situation where you may have to discuss the nitty gritties of how you enable that, I think at that point it's not just a cursory discussion, it is a very serious discussion. So at that point I would say yes, do strongly consider an NDA before you divulge more details. Usually these are done, like even let's say for a tech transfer sort of a discussion, it's at a very serious stage where you have something to offer and the other side has something to absorb. So this will naturally come. It's a good practice to do it. So thank you for asking that question. And your related question is, as an academician, you may have limited resources versus the industry. And so should you file a provisional patent and then discuss the concept? Yes, that's a good practice. The provisional patent, however, is just a protection mechanism, right? So do keep in mind the timelines, that if I'm filing a provisional patent application today, within a year's time I have to complete the full filing. And if I don't do it, then I basically don't have anything to enforce my rights on. So before you divulge anything at a public forum, it's a good practice, particularly for our research community, for our startups, because you will be going to different scientific conferences. You may be going to different pitch competitions. At all these places, you have to consider that these are public events. So if you're going to be divulging anything which is of importance to you, it will be counted as a public disclosure. So imagine if you presented that that exact process, which helps 10x the performance of your product. If you divulge that thing today and tomorrow you file that as a patent application, the patent examiners could pull up your presentation today just one day before and say this is public knowledge. So your own presentation can work against you. So that is one aspect. And the other is also you're protecting any unintentional infringement as well from others. So yeah, do consider filing of provisional applications highly recommend it. Dr. Swati Joshi asks if there is any source to get industrial problems on one platform so that they can motivate researchers to pick anyone from them and start working. Yeah, Dr. Joshi, there are numerous initiatives which are there, some by the government and some by the industry. So, for example, if you go to the Agni website, AGNII, that is an initiative of the principal scientific advisor, you can see some of these opportunities which are there for commercialization. You can also see sometimes, there are sites, there are industry bodies which are discussing these things. However, a lot of these are not uh, put necessarily in a single domain, right? So you may see, for example, open challenges. You may see hackathons which are there around a certain topic. So that gives you an indication and a glimpse. Some of these challenges are found on portals such as the Startup India portal, where an industry is issuing out a challenge which is open for the public to solve. So that's one way of doing it. The other approach that I have seen is to have, as an academic, I would say, have try to have good relations with the industry professionals in at least in your surrounding area. So some of the good institutes that do tech transfer, what they have enabled is an open access to their professors. So quite often the industry representatives will come to the institute and they will say, we are facing this problem. And why it is not explained in an open state, firstly, is because of confidentiality reasons also. But sometimes also they want an, you can't convey something like this in, like, say, one paragraph on a website. So they may want to have like a half an hour presentation with the professor and the research group and explain the importance of what they're trying to do. So if you have those sort of relations with the industry in your surrounding regions, you will develop this natural funnel of good problems to solve for the industry that ultimately benefits the consumers. So I'm trying to go through the chat box to see. It's good to see a very lively chat box. And again, nice to see how you all are joining from different parts of the country. Professor Kudalkar asks, a product exists in market with a different feature, but is not useful. And the innovation applied is going to increase usage and value. Will it be a patentable innovation? So the three criteria for patents are firstly, it must be novel compared to what exists before. So if your method is new, I would say that is going to be a primary criteria compared to what exists today. The second one is it should not be obvious, meaning the development of that method, how to enable that, should not be obvious, and that's a separate criteria in itself. And the third one, which I think what you're alluding to, is called as the utility criteria. So the patent officers and examiners, they determine if that invention is going to be useful to the public. And now, because the previous method would fail, considering what you've said, your new method is going to make it more useful. So if you met the prior art criteria, meaning it is novel, if you met the obviousness criteria, and if you met the utility criteria, then it will be a patentable invention. Yeah, feel free to connect with me on LinkedIn also after this. Maybe uh, the Turnip team can post that. I believe they may have done it. So I'll be very happy to answer questions outside of this as well. There's one question from Sushant Singh. Is it good to file the provisional patent early or wait for the prototype to be developed first? So, Sushant, with a provisional patent, you are in some sense buying time, right? So, if your method is pretty solid, so assuming it's a method for method type of an invention you're talking about, uh, before you've implemented, you could consider the provisional patent application because that gives you 1 year's time. And within a year's time, if you're able to converge on that, you can file a full application. Now, if your method changes significantly from what you disclosed in the provisional application, you could explore filing of a new patent application. Okay, but the rights will be valid from that new date. So I would say uh, if your prototype development is going to take a lot of time and it's going to be deviating significantly from your path, maybe wait. I can't give you a clear answer because it's a very specific situation you'll encounter. Generally speaking, what I've seen is if your method development is more or less done, even at the block diagram level, you could consider filing the provisional patent because you have a greater degree of confidence. It's a risk you're taking, but it probably could be worth it. Okay, I think we are good with the questions which have been asked. Rahul, thank you for joining. If
Great.
there's
Thank you
something I
so
missed, please
much.
let me know.
Yeah, that's great. That's great, really. I mean, innovation, like people, technical stuff, and the business. I think the innovator has to do all. So, innovator at least has to have an eye on all of them. So, basically, for commercialization, the innovator is the central piece. No one can come and do everything for you. So great insights. Thank you, Hemang. I think that we will wrap up this session, and there are contact links. We've posted the LinkedIn profile of Hemang, and we have posted a newsletter of Hemang where you can sign up and you will get emails from him. So you can also reply to those emails and ask your questions. So great, Hemang. Thank you. Have a great day, and we will continue now the Turnip Innovation Festival into geographical indications
Great.
with
Thank you so much,
Professor
Rahul, and
Ganesh.
the Turnip team for having me here. Thank you to all the attendees. Best of luck with your innovations. Bye.
Thank you. Absolute pleasure. Thank you. Bye bye. Yeah.
Bye.
So please write on the chat how it's going. Are you enjoying the Turnip Innovation Festival? Just type yes on the chat if everything's going well. So our next speaker is Professor Ganesh Hingmire, and he is one of the most renowned personalities in India in the IP field. His expertise is in the field of geographical indications, which is a uh, very underrated form of intellectual property. It is so powerful, geographical indications, that it has the ability to uplift entire indigenous communities. So, Dr. Ganesh Hingmire, he is going to talk about the role of GIs or geographical indications in commercializing indigenous products. And he will speak about cultural entrepreneurship, how cultural entrepreneurship can be enhanced for the upliftment of the indigenous products. So, Professor Ganesh Hingmire, he is well known for his passion for IP. He has 2 consecutive national awards for best facilitation of registration of GI and promotion of registered GI of India. Additionally, he has more than 15 years of experience in consulting and teaching. So he has led numerous IPR training sessions for government employees, including Assistant Commissioner for Food and Drugs. If I am not wrong, he has enabled filing of at least 30 geographical indications from different parts of India. So let me see if. So yeah, with this, I would like to invite Professor Ganesh Hingmire to the stream and welcome him. And sir, the stage is yours. We can see you and we can hear you. So really grateful that you are here, and we are looking forward. Thank you.
Thank you, Rahulji. Let me first correct very little information that we have had an opportunity to work for 75 GIs from 6 states of India, and now the 7 states has again this started. Uh, then basically more than 45% amongst our all geographical indication applications are agriculture application, agri GI, what we can say. Uh, yes, before I move to my presentations, basically, I would like to give a little background on geographical indications. As rightly mentioned by Rahulji, this is somehow untapped uh, area of intellectual property right. We all know about the various forms of intellectual property right: patent, copyright, trademark, industrial design. But unfortunately, we can say the most important intellectual property right, but not really commercialized in the right way. So I would be taking you to the next, basically this stage of commercialization of intellectual property right called communities intellectual property right. By name, you can say geographical indication, that is GI. And there are different type of communities are involved for GI. And GI is a geographic specific. Say, for an example, Darjeeling tea. Darjeeling tea is an agriculture GI from West Bengal, and you will find this tea is unique. So GI is number one, is a community's intellectual property right. Number two, you can say this is geography specific, your area specific unique product. And that product carries some uniqueness in terms of nutritional value, in terms of you can say medicinal value, or in terms of some aesthetic values and etc. So that area, that particular area gives uniqueness to that product, and that product gets the identity as a special tag in the form of geographical indication, and that is a community's intellectual property, where we can say this product is entitled to fetch premium price from the market. That is where the geographical indication is plays an important role. So this GIE, you can say, can be granted to three types of goods. One is agriculture good, which I have mentioned about the Darjeeling tea. Second is a manufactured goods can also get the GI as per the GI Act enacted in India. It may include textile, it may include handicraft, it may includes handlooms, and it may include certain kind of liquors. So Goa Feni is manufactured goods. So that is example you can see. Then Banarsi sari, Chanderi sari, or Paithani sari, those are manufactured goods, are supported. The third category in India where you can register as a GI is natural goods. So natural goods, we have two natural goods registered as a geographical indication, and I can give you one example is a Makarana marble. Makarana marble from the Rajasthan received the GI for as a natural goods, and you will find Makarana marble is used there in Taj Mahal and also Victoria Palace. So, in short, let me summarize the introductory note on geographical indication. Geographical indication is intellectual property right. Number two, this is communities intellectual property right. Number three, there are three categories of the goods can get the geographical indication. A, B, C. A is agriculture, B is manufactured goods, and third, C is natural goods. So these are the goods which can get the geographical indication as per the India's Geographical Indication Protection and Registration Act is concerned. This act we have enacted basically in 1999, however, came into force 2001. The first GI was registered Darjeeling tea, and today you will find Darjeeling tea can only be produced at Darjeeling, and today you will find Darjeeling tea is getting a premium price. So that is a success model of Darjeeling tea, where you will find in quality tag in the form of geographical indication is given to the Darjeeling. So that is what where I am concluding. Geographical indication is there to give the premium price to the community. Geographical indication is the area specific goods which can carry reputation, goodwill, and entitled to get the premium. So now let me start on the today's topic: how we can commercialize the geographical indication, or can be cultural entrepreneurships through the our geographical indication. Yes, there are. Basically there we have to be very focused, otherwise I will not talk much on the geographical indication, the process, the registration, technical part, legal part, requirement, etc. We have already covered in our previous session, where you can click on Google and find nation building with the GI. But today I'll be more focused on entrepreneurship, more and furthermore focus on cultural entrepreneurship through the geographical indication, and where we can take the help of the various example or success stories happen there globally. At the same time, what will happen in India and what had happened at my personal end, as I have had an experience of working on 75 GIs, and rightly mentioned by the owl, we have received the success, we have received the registration for the 29, and many of them already successfully commercialized. So let me start with one by one. What is the global scenario on geographical indication? Let's start with the China. They have more than 9,000 GIs in last years. Then you will find in European Union they have 60,000 GIs, and you can see that Hungary and Germany, they have more than 15,000, and GIs are in force. Here is the crux for today's entire session, where you can see during pandemic also European Union particularly utilize this community's intellectual property right for their support system, as a support system for the economy, where this news is very specific about the GI sale value in Europe in 2020. The GI sale value in Europe you will find is 75 billion euros. So, and what one can imagine how much is the revenue they have generated. And further, you will find more around 15 billion euros they have generated through the exports. So it's very clear message to all of us that if you have a geographical indication that carries a goodwill and reputation and identity, and there you can fetch the premium price, there you can also fetch the foreign exchange through exporting your goods to the other countries. Further, you can also say you are helping the international community, giving them a unique product from your place. And that is what successfully European Union did. Their champagne, their Scotch whiskey, their sweet chocolates are available in India and any part of the world. So what are those? Those champagne, the Scotch whiskey, and the sweet chocolates are registered geographical indication. They called it as a PGI, protected geographical indication. And then successfully they have grabbed the all over globe market, and their unique product is available worldwide. So here is the message to all of us that commercial exploitation of your unique product is possible through the GI tag, and that is commercializing the geographical indication is very important. And you will find these products are not new product, they have a history, they have uniqueness, and they are from particular area. So when you say history, its history can be traced back to ages, hundreds of years ago. The indigenous community began on that. So champagne you can see from the France, from the small village, but there that is a kind of an heritage tag from the champagne, and that's why that is also we can call it as a cultural symbol, and these are from the certain communities. So we can say specific kind of communities applied their intellect and created a unique product that can be protect not only community but also protect or promote the entire nation's economy. And there you can see a number of examples are there. Some of you might have heard about the Switzerland cheese. You will find more than 65% cheese from the Switzerland, which received the geographical indication, is exported. So you can imagine that how it works. Then there are also examples from the global scenario or pictures you can find. The coconut from the Thailand that has been now available in the market for almost $10 per coconut after receiving the GI. So one can imagine those who are from India, they can see only half of the dollar, maybe 50 rupees per coconut you can buy. But the coconut which received the GI from the Thailand is now fetching a good price. So these are the various examples you can see, and they promoted like champagne. They promoted in such a way that even we won the World Cup. Our Tendulkar and other teams celebrated our victory with the champagne. So they promoted their unique product, particularly in a way that that champagne should be utilized as a celebration drink. And today you will find that champagne is available in any almost all part of the world. So that way geographical indication is promoted or is possible to promote. Here is the particular, you can say, GI registration division on particular European Union side, where you can say more than 51% GI registered there in Europe are basically wine and spirits. So what I mentioned about the champagne, Scotch whiskies are example of those registered GI. Then 41% products from the European Union are GI registered products are agricultural products. And handicraft, they have very less handicraft. So we have a good opportunity to export our handicraft products there in European Union. They are regularly using pashmina shawl. Pashmina shawl from the Kashmir is registered GI. Then also kesha, that what we can say saffron, is also registered GI, and they are in need of such kind of unique products. So those products are already registered GI, but yet to get the international market. So then now I'm coming to the work what I have done from my side, and some of you might have not even heard about the name of these various geographical indications. See, these are the different alcoholic beverages from different states of India and entitled to get premium price, but unfortunately not yet reached to the market, and their uniqueness is not yet available to the public at large. And hence I think that's the possibility, and I'm going to cover the chart of comparative, the particularly comparative chart, how much price champagne is getting, how much price Scotch whiskey is getting, and even these unique alcoholic beverages are better than those product to in some contexts. Still, they are not receive the premium price. However, they are potential and they are from the indigenous community. Let me repeat, these different products are from the indigenous community. Now, let me explain one by one. Sur. I don't know how many of you have heard about the Sur. So Sur is basically from Uttarakhand. There is a Jaunsari community, indigenous community from the Uttarakhand. They have a legacy of this beverage. They are staying at top of the Himalayas, and they are in need of certain energy source. So for particularly an adverse situation like at top of the Himalaya, they have there some good food culture and also beverage culture. So there they have this product called Sur. Sur is from Jaunsari community at the Doon Valley, and they prepared this Sur from the available particularly herbs in that region. And you will find this when we work for this GI, we also got the references from the Charak Samhita, where you can say Kintu, the statement say particularly available from the चरक संहिता किंतु मध्यम स्वभावेतम यत्र यात्रा तथा स्मृतम अयुक्ति युक्तम योगाय युक्ति युक्ताम यथामृतम. It means particularly, you can see it interpretation in English, but alcohol by nature is like a food in consumption and giving energy. When used in appropriately is for getting a disease, when used appropriately is like a nectar. So this is from the Charak Samhita. So we have a history, we have a record, we have a references with respect to the use of beverages since ages. And you further find this photographs, and then this is from the reference where history is trace, and then this is a product from the community. They have kept this community, and I have had an opportunity to work for this product as a geographical indication, and this product will get GI very soon. So then another product is Jogran. This is from the Assam. I work for Assam. There are other states. This is a rice beer, and this is a distill from the rice beer. Basically, you can, it's completely transparent, and this is a product of our specific indigenous community called Bodo. So Bodo people are there, mainly are originated from the Bodo land of the Assam, and these indigenous people, indigenous community also residing in the forest area, and they have their own, they are very close to the nature, and then they take the sources from the nature and prepared or produce a unique product, and were not only helpful to them but entire again globe, but unfortunately not yet properly tapped. But fortunately I had an opportunity to work on this unique product from the Bodo land. Particularly Bodo is a tribe community. They have their regular culture called this Jogran. Jogran is, as I mentioned, is the rice beer. We have applied for this GI. This is a transparent color, transparent. You won't find there is a difference between the water and this product. And I've seen the entire process. It's a fantastic, and every home you can easily prepare that. That is what their culture, and they have an available raw material in adjacent area, so they utilize all the raw materials for preparation of this alcoholic beverage called Jogran. Jogran is part of their tradition. Jogran is part of their culture. So these indigenous community, they have this product, which is even an alcoholic beverage, but it's a nutritional or medicinal as well. We have found many article research papers on that, where we found that this beverage reduces the sugars and provide many nutritional ghatak or point to the individuals. So this is their tradition. During the festival season, they particularly utilize this product in a very precise manner. There is another product I have had an opportunity about this product called Chung from the Ladakh. So I work for this another alcoholic beverage. This is also from the indigenous community from the Ladakh, where you can see it is based on barley alcoholic beverage. This is Ladakh, and basically we know the Buddhist community is particularly residing in this particular area of Ladakh, and they have monastery. They have different type of structures, and they are using this Chung as a part of their culture, as a part of their traditions, and since ages. Again, I mentioned many hundreds of years they have. And fortunately, we found research paper of their this uniqueness product from California University when we applied for a GI. So to apply a GI, there are many aspects need to be considered. Number one, history. Number two, community. Number three, uniqueness in terms of, as I said, nutritional value or medicinal value, and area where the product is available. Again, you will find this area, the product is attributed to particular area only. So when I say Sur, again, top of the Himalaya to face the adverse situation. But their products are nutrition. Chang is also that. Jagran is also, those are at the foothills of the Himalaya, located in the Assam area called Bodoland land. So here you will find these are the indigenous community, and they have their unique product. They have their specific cultural product that need to be recognized. Hence, we work for their GI. What had happened to the champagne can happen to our unique products from the India. What had happened to the Scotch whiskey can happen to the India, and that's why we took one step ahead on these various unique products. So then I also have had an opportunity to work for this rice-based another uh, alcoholic beverage from the Assam called Maibra. Maibra is a rice over there, and it's integral part of their socio-cultural life of the Bodos. Basically, Bodo people's worship for the Sinju. Sinju means five. Five. We know that five elements basically, or water, then your Tej, Surya, then Vayu, it's air, and then Akash, ethers. So they have this culture of the worshiping the five. So this is also reflected in their food culture, in their regular day-to-day life. It includes about the daily consumption of the rice, and they have a different type of rice, including Maibra. That is one of the rice which nutritionally very high, and you have a special alcoholic beverage process and utilization of the Maibra, that is called as a Maibra Jaw Bidwi. So we have seen Jaw Gran, then we have also now discussing Jaw Bidwi, that is from the specific kind of a rice, that is also rice beer. Bodo people believe that Maibra Jo Bidwi is a symbol of great status and prestige. So it's a symbol of when we also have that, leaving of standard and exchange. So when you utilize, when you graduate, you have head care. So it's a symbol, it's special. During the marriages, it's like particularly offering the Maibra job BDV as a consider as a prestige, that what culture they also have. So this is a different rice beer, you can say, on a upper scale, and it's a different kind of people are basically utilizing this. Now, Mawa. Some of you definitely might have heard about the Mawa. This is another product I have worked from the Maharashtra, which is actually border of Gujarat, in Nandurbar districts. We work for this. There are again unique features you will find for this Mawa. This is a flower-based alcoholic beverage, basically, where Mawa is a tree naturally available in some tribal belt in Maharashtra and say other states as well. So Mawa, when I work for the Mawa, I found they have padas, like we have particular talukas and all. So they have padas. The tribal community located in certain that forest belt is there is using this Mawa as their regular uh, product, and these products, basically Mawa is prepared from the flour. So this is a flour alcoholic beverage, as I mentioned. So here we can particularly say, I when I was working on this product as well as let me share my practical experience. We know that delivery, particularly birth of baby, and then we this we have doctors in city areas, and even nowadays in urban areas, as well as rural areas, you will find government hospitals are there. However, in forest area, in tribal area, there are still not have a direct access to the doctors. In such situation, there is a assistance available from the woman, traditionally called dai. So she goes to the tribal people's home, and she helped to deliver the baby. While delivering the baby, she used Moa. So it's a natural antiseptic product, you can say, and that's how. Basically, again, I'm saying how unique products are there. They locally tribal people called Moa tree as a kalpataru. It's giving you lots. It's giving you everything. So that's how it is a kalpataru. So this is another product what we have worked. How commercially all these products can be successful. Here is the best example. Goa Feni received the GI, and thereafter government of Goa declared Feni as a heritage drink, and thereafter they started selling the Goa, and recently last year they have come with the policy called Feni Policy 2021, and now they are getting the good price, and the unique product is only available in their that particular place. So government also getting the revenue. So what does it mean by commercialization? Commercialization getting the premium price, commercialization getting the revenue to the government, commercialization includes the employment to the people, commercialization is equal to the recognitions, commercialization is included to the enforcement. So if I'm from Pune, wanted to sell the Goa Feni, I cannot. That's another part of the another side of the coin, what we can say. Enforcement is equally important. So there you can see commercialization of geographical indication is perfectly happened to Goa Feni. Now let me tell you now as I mentioned, I will give the comparison of this GI registered product. So apart from champagne and Scotch whisky, tequila is also registered GI. See the price on the right hand side, and you see the percentage of alcohol and raw material. So our raw material, what I mentioned about the Maua, what I mentioned about the Chung, what I mentioned about the Sur, what I mentioned about the Job brand, what I mentioned about the my bra Job Bidwi. So these are, I just mentioned about the five, that product which we have identified. Actually we have identified 15, but we work for the 7, and now I've just covered here is only 5, where we have a lot of commercial potential. And what had happened to the Goa Feni can happen to the Maua, can happen to the even Chang can happen. And that's why we have identified, we have worked, and we have applied for those GIs, and those GIs are in final stage of registration from the different states of India. So you can see the price right now is hardly 50 to 100 rupees to the Sur, and that can, even though that Sur is much better than the other GI registered, but price is very, very, very less, and hence we need to get it recognized. Once it is recognized as an intellectual property right of the indigenous people, then it's from the unique particularly, and then you can say get it globally. And fortunately, there are many research papers you will find on the uniqueness of these unique indigenous product of the indigenous community. So that's why I'm trying to work. So now coming to the another GI's part, where I mentioned about the manufactured goods. So these are the different further musical instrument, then textile, then handicraft can also get the geographical indication. Again, those products are you will find from indigenous community, and they need to be commercialized. We know the violin, but have you heard about the sarja? Sarja is a musical instrument of the Bodo people. I have worked for this product, and very peaceful sound you can generate through this sarja. So that's the fantastic. I've tested, I've listened, I've enjoyed, and those are really. And today, during our stressful life, such kind of musical instruments are very, very, very helpful, which will give you the lot of peace. Then you can energize yourself, and then you can again get back to your work. So such kind of musical instrument which are prepared by our forefathers continue with our indigenous community. We have certain history. There are some mythological stories attached to this sarja, and even the rivers started listening. That's what the mythological stories I have narrated in my application. It was there, say, available in many books, and it's river from the forest. She started coming back just and flowing from the forest because she wanted to listen the music from the sarja. So that's how the many interesting facts attached to our unique product, and that's what I'm just mentioning about the sarja. Then I have worked for the jotha. I have also worked for the shifang. I have not covered here, but shifang is a bansuri. What we know one basuri with 6 holes, but this sifang is for 5 holes. So we want a piece, and our forefather have already made an arrangement. Through the music, you will get the peace. Through the music, you will get an enjoyment. Through the music, you will get an energy. And those instruments are already available. It includes calm also, where these are the different instruments what I have had an opportunity to work, and hundreds of years history they have. Further, I have also worked for the various silks. So these silks particularly uh, silks, here you can see on the left, on the right, where I work for the Erie silk. Erie is also known as a Indie silk. Indie silk, that is basically also known as the Ayunsa silk. The silkworm from this silk will not die. It will go back to the nature, and that is also available from Assam's borderland, and Bodo people are working on that. So here is the silk you will get. Here is the manufactured goods which you get, and the nicety of this Erie silk is the life is 160. So your 3 generation can use that. I've seen that all 170 years old silk product from the Bodo land when I was working on the field work for these products. So these are the different musical instrument. I have already mentioned about the serja. This is me actually when I was using the serja, which is a traditional musical instrument, and giving you a piece. I have already mentioned, and that is actually, if you compare it with violin, we should not compare with this any. Someone may have the cultural musical instrument like a violin, but ours is Saja is better. Sifang I have already mentioned. You can see that there are only 5 holes. So Bodo people in believe in 5. So they have Sinju, that is a tree. In every home you will find a tree of 5 elements, and they are worshipping for those nature's essential 5 elements, and that is your condition. So then calm. This is again a different type of musical instrument which I have worked for the geographical indication. When I was working on this instrument, and then we found they play this instrument, and they have 2 objectives behind while playing this calm. One is to bring all community member together when they start playing on this. So community member gets the message, oh, let's come together for a good cause, let's come together to support Sitaja, let's come together for helping to each others and enjoy and entertainment, and likewise. So this is one objective. The another one is when you during the play it's create such a big sound, then it goes to the Himalayas top, and they say, okay, let's convey the message to the Lord Shiva through playing this kham. So that is another object of the kham which I work. And then Jota, I have already mentioned that you can play while playing it. This is a supportive musical instrument, but mainly it's different in size, it different create a different sound, and ultimately this is again unique product from that. So this is a gongona, again a woman particularly plays. It's a genre of play, and then it's again say uh, it's such a beautiful culture what we have in our country, but unfortunately not really tap or reach to the right people. And then that's, I think we need to work. I have also worked on these different unique product. I have registered Paithani Sari in 2009, and today you will see there are movies on Paithani Sari. There are shops on Paithani saris. Then there's particularly recognized as, you can say, a unique product from a district called Aurangabad, place called Paithan, and also there is another area where Paithani is made in Maharashtra called Yavle. So these are the different product, and this is also called as a Deva Vastra. Particularly, it has a long history of this Paithani sari. Likewise, I also work for the Aronai from the Assam, Jimra, and also Dokona. This is another traditions culture they have in Assam. If you go there, then they will welcome you with this dokona or aranai. So it's a welcoming vastra, you can say. They have cultures, and these are again from the indigenous community. We can exchange our cultures, not a culture, our culture remain as it is, but we can say exchange our some process of welcoming. Instead of gifting some type of flower, we can give this dokuna or aronai. So there will be more employment, since this is recognized as a special product, unique product by the indigenous community. That will help the protection of unique communities product, further promotion of the unique products. So this Paitani sari, Puneri Pagdi, I have registered this headgear from Pune in 2007. This is a very successful story at my end. Uh, when I registered this Puneri Pagdi, I have had a history from Chhatrapati Shivaji Maharaj. Then you will find during the Peshwa also, and one can recall the particularly movie called Bajirao Peshwa. That's Bastani's movie where pagdi is used by the Peshwas. And even I can refer during the British era, particularly Lokmanya Tilakji. You won't find single photo of Lokmanya Tilakji without using the Puneri pagdi. Even in Pakistan right now, there is a school named Narayan Jagannath Vaidya, established, the first school established in Karachi in 1955. That school name still remain as a Narayan Jagannath Vaidya, and 1855. 1855, this school was established, and still it's there in Karachi. You will find the Narayan Jagannath Vaidyaji's photo with Puneri Pagdi. So during British era also, this has been used. Initially, it was used as a of symbol of intellect. But when I registered, we have claimed this become a symbol of heritage, symbol of culture. And recent last week, G20 delegates visited Pune. Everyone honored with Puneri Pagdi. So one can say the cultural entrepreneurship's best example is Puneri Pagdi, what I have at my aim. So we recognize it, we identified it, we registered it, we promoted it. Not only became a symbol of welcoming the guest, but nowadays we have requested that day during registration itself, we requested to the University of Pune to replace the convocation hood, and recently University of Pune replaced the convocation hood with the Puneri Pagdi. So in due course of time, there may be a demand of 5 lakhs pagdis per year to be made. And that's how cultural entrepreneurship will be helping the employment generation, then also prosperity. So we have this. Then Hiri silk, I have already said about the particular, you can say, it's Ahimsa silk from the Bodo people, naturally and long lasting, and then it's very unique. Arunai, you will see the design. It's very nicely designed, and then there you can say mountains, and then their culture, and that's a welcoming symbol. Then this is a dokona. They use it. This is again from the indigenous community. We have a lot of, and then this particular product you will find. It's protecting you from the various reason. And nowadays, because of the environment change, because of the climate change, rather, I would say, we need to be protected our body, and the product like from our indigenous communities are very useful. So then further, our food cultures. I have worked on these various products. Olla, it's again a natural one from the available resources. I also work for the Borsari Dal, Guaca Guaki, where you'll find 101 types of herbs are collected minimum, you can say 34 to 101 you can prepare, and guaca waki is the most nutritional food. And I think once you have, you need not to eat for another 2 to 5 days. That's kind of these things. So Ranya Rote is what I have worked from the Yavatmal. Then Renuka Mata Tambol is like, it's a pan from the Nanded districts we work. In Sanskrit, it is called as a Trayodashi Vida. That's you can eat it. You can you basically you will get a good energy and its help to the digestion system. Nafam is another product. What I have worked is a fermented fish, and then uh, 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 basically it's a unique product. I will not take much of time because my I think there's five
So we
minutes
can take
left.
one question if it's possible. One question actually
Yes.
from the
Uh,
audience.
yeah,
Actually, I'm
yeah.
also curious. So suppose sir, two GIs are looking very similar. So there's one question from Darbha Shastri. So
Within
how
two
do
minutes,
GI
I
products?
within 2 minutes
Yes,
I'll
yes,
finish these slides, and then I think that will be good.
sure,
So this is
sure,
how
sure.
we work. I have mentioned about the NAFAM. This is how we are working at the, to protecting the intellectual border of India. So you need not to be a soldier always to fight the, to protect your country's border, but you can protect your country's border intellectually. That's how intellectual property protection at border we work. And state-wise, these are the different states where I work, and this is how we have protected uh, intellectual property at India's border. And this is how Maharashtra, I have had an opportunity to work for the 49 GIs. And this now we can take questions, whatever it may be. Please.
Great, sir. Thank you so much. Really, really appreciate this unique insight and unique IPR that very few people are talking about. So yes, this was the question. How do GI products are differentiated with similar products? So how is the, if there are similar products, how GI tags can, how GI products can get an advantage?
See, I can read one question. Kham looks like a mridungam. Absolutely right. Mridungam, I'm basically from Maharashtra. I know, and I'm basically from the Warkari Sampradaya. So I uh, have complete idea about the mridung. This is also a musical instrument. However, if you see the size, if you see the raw material use, if you see the intention behind of that particular size, and the woods which that the trees which are available there in Bodo land, that's altogether different, and it creates a big sound. And the playing of that calm is also unique. And I can request them, they can go to my Twitter or Facebook. I have already uploaded that, this that while playing the mood, this calm, what kind of songs they generate. And it 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 is fantastic. And I have personally experienced that. So mrudung playing is for, again, that is again the religious aspect. And God, again, message is to, to get the peace by religious way through the playing of such kind of instrument. And then it's similar line, but at that level where they don't have power, electricity and etc. Instead of mrudunga, they have a calm. So it's a different, but it's in the similar line, in the similar thought, in the similar way, to give the peace to the humanity. Can individual person apply for a GI? The answer is no and yes. No means only community can apply for a GI. They are the registered proprietor. However, after the registration, individual who belongs to that area, who intend to keep the quality of that product intact, he can apply for authorized users registration. Authorized user means individual who is into that business, who is already producing that product, or who may be a farmer or artisans or weavers. He can get individual certificate of GI in his name, and that is authorized user certificate. and that is what we called Part B registration.
Great, sir. Thank you so much for your time. Really precious to hear these words and think about intellectual property more away from the technical side of patents and so on. So grateful, sir. Thank you. Have a great day, and we will be in touch. And we will now continue Turnip Innovation Festival with our next speaker, who will talk about fundamentals of IP acquisition, and Dr. Anindya Sircar. He is with us. So thanks a lot to Ganesh sir, and so we continue our program.
Thank you.
So, Dr. Anindya Sircar, he is a very well-known personality in the IP field in India. He is currently IPR Chair Professor at NALSAR University of Law in Hyderabad, where he's doing consulting, he's strategizing on IPR issues, he's teaching and taking training programs in IP management. His last employment was as an assistant vice president and head of IP at Infosys, and was responsible for IP activities of Infosys at a global scale. Prior to that, he had a very long stint in the IP department of Biocon Group, a premier biotechnology company, and he was instrumental in setting up the IP department for the Biocon Group. So, Dr. Sircar, he is a registered patent agent. He has 2 PhDs, one in science and one in law, and he has been figured in the Lex Witnesses Hall of Fame, top 50 prominent lawyer in India's legal sector in 2010. So with this, I invite Dr. Anindya Sircar to the stream. Sir, welcome, and the stage is yours. Really excited to hear your words on acquisition of IP, on which very few, if any, people talk about. So thank you, and sir, the stage is yours. Sir, you are muted. Can you unmute yourself?
Am I? That's it. Okay, thank you a lot, Rahul, for your kind introduction. And I was just hearing to the previous session. I mean, the speaker is a good friend of mine, and the wonderful thoughts which he presented. See, you might get disappointed the way I have planned this, and I have a discussion with Rahul. And the way I have planned this is that I'll have a very small presentation, 15 minutes. And I want to take more questions from you people. Okay. Now, shall we? And you have every right to stop me, ask me question in between, and also towards the end. And although I would prefer questions more towards the end because that disturbs the continuity of the presentation, and we will take it that way. And Rahul, shall we start with the presentation?
Absolutely, sir. Yes.
See, when I'm talking about this, IP acquisition, this is a big term. It's a fanciful term. It's a term which attracts a lot and doesn't creates a lot of question on how you really want to acquire IP. Every researcher on whichever side of the table is sitting get carried away by this word. That's what I do. That's what I want to stop. See, when you are in a business, see, IP is a tool to help you in your business. An IP acquisition is one of those specialized category tools. Now, IP acquisition, if you really ask me, it's going to be whether you are going to buy IP You buy so many things for your requirements, for your normal function of life. The same thing is, do you need to buy something for your regular functioning of business? Or I am going to change this IP acquisition to a little different mode. As far as I've understood from Rahul, is that we do not have many acquirers who are in this forum. There may be people who want to sell their IP. That's also IP acquisition. Who the other guy, where you are on the receiving end, or you are trying to sell. So let's look at that IP acquisition with a new term, IP transaction, so that we understand as and when required, you are on which side of the table. Now, see, this is business, hardcore business. And there's a lot of money involved in it. There's lots in stake. Whether you're a startup or a mid-sized company or a big-sized company, when you talk about IP acquisition, there's a lot of money in stake. So every decision is important, critical, and has to be taken with a lot of exercise so that you get into a meaningful conclusion. I have a simple mantra for that. Okay, whether you are selling IP or getting IP or buying IP, the question is show me where is the money. If there's no money in that, if there's no benefit in that, this acquisition doesn't really work. Now, why is this become important? Just let's look at it. Why were we talking about IP acquisition so much? Because it's sometimes an easier shortcut. Okay. And the reasons why this is an easier shortcut is that there is a huge growth in mega licensing. You'll find, the entire portfolios of company A being, acquired by company B. So like Microsoft Enter IP was acquired by Google. There's a boardroom pressure because IP all along has been a cost. Now, if you want to make it as a revenue, there's a pressure. Of course, there's going to continue as always a debate between patent quality and quantity. Quantity gives you muscle power, quality gives you an edge. Okay. And then, things have become so nice and improved that we have more and more patents being granted every year. The number is on the rise. That also creates a pressure. And fortunately or unfortunately, whether it's Wall Street or the Lal Street, they have all started taking an interest in IP. If you get a chance to read Wall Street journals, you'll find that there are frequent articles on IP acquisition and IP issues. Additionally, IP licensing is now a profit and loss drawn business. It's a P&L unit in the company. I know of so many companies, so many organizations where this is a business unit, which has led to a tremendous amount of internalization. And, and to add to this, there have been tremendous amount of legislative and judicial changes, which helps it. There's an increase in standard essential patents. There is an increase in the damage cases. People are going to get, have been able to get higher damages. Hmm. And of course, when we talk about size, yeah, of course, portfolio size matters. Okay. May not be in theoretical matters. If you have a bigger portfolio of 1,000 patents and I have a portfolio of 20 patents, size, muscle does matter. But having said that, I will also say that if your 10 patents are so critical, it can knock off that 1,000 patents. See, and neither the cost and and the expense are linear in this aspect. Now, why you want to acquire IP? The question is why you want to acquire IP? Because you can't build it, or you can't build something which is non-infringing, or you do not have the time to build it. You want to get into business. Whenever one wants to acquire an IP, the conflict is between build and buy. Can you build the same stuff, or do you want to buy it? And the questions and the others aspects which are important are what is the timeline, what kind of skill you have, what is the research cost, development cost, who are your competitors, and then taking it forward. Sorry, there is always an uncertainty of success. Every development program doesn't really take you to a success level. Okay, so and what kind of budget you have. That's when you want to buy. But when you have a developed IP and you want to sell, that's also part of IP acquisition. What do you need to see that what kind of shares you have, the market share you have, what kind of control you have on the IP. And remember, when you give your IP out to somebody, you might be giving birth to competitors who will be competing against you. So you need a more justified, diligence to be done so that you have meaningful uh, progress on the business. Now, having said that, I would also want to say it's not buying and selling anymore. When you talk about IP, it's not just acquiring IP, I buy somebody's IP or I sell my IP. The entire game is on licensing. When I don't buy the license, I don't buy the IP, I take a license to use over uh, over agreed territory, over a uh, agreed terms and conditions where I license it, which has some advantages because some of the liabilities of that IP still stays with the owner. You're not buying it. Now, I should also point out that IP is not, when you talk about business, when you talk about acquisitions, it is not just IP. IP will lead you to patents, copyright, trademarks, geographical indication, trade secrets, and if you are in agriculture, plants, variety act, whatever. IP doesn't end there because business करना है धंधा चलाना है. So beside intellectual property, there's also something known as intellectual capital, okay, which is basically, you can see these are the human capital, people who run it, the organizational capital, okay, and the technical know-how. You need to know that as well. So all that put together, I would say it's nothing like in a transactional process. Every business transaction which you and me do, it is no on for our daily livelihood, it is no different from that. So I thought of looking at a definition of business transaction. And what I found is that it's an economic event that indicates accounting process of recording in a company's accounting system. Okay, that could be even be a garage sale. But when you look about IP transaction, there should be something intangible in that business transaction. Now, this is a very simple but overcrowded slide. What I mean by that is that this is the complete cycle of IP transaction, where you have here on the left who generates IP, and here on the right who utilizes that IP. Now, you can go through one or multiple processes. I'm not going to read all of those out. You can have a look, which takes you there. It's not that you need to go through all of them. At least you'll have to go through some of them. Now, that doesn't mean that you generate an IP and you sell it for somebody or assign it to somebody or license it to somebody. You can use your own IP for your own production. I mean, that's the business cycle if you are internalizing your IP. And mind it, if you ignore it, it's lost forever. Okay. So you can't get out of this cycle. So what's important? Important are three things: goal, plan, strategy. You need to have a transactional plan, you need to have an IP strategy, and an effective means to say what is the value of your IP. Is it just those, those half a dozen sheets of paper in which you print your patent? That's the value of your patent? Or you can put a dollar value to that, which is higher, which makes business sense. So, what kind of transactions are we looking for? When you're looking for IP acquisition, there are only primarily three kinds. You can license your IP, you can assignment. Assignment is nothing but a sale, or you can look at, you know, uh, technical know-how transfer. Okay, it's a know-how transfer, often accompanied with licensing, but need not be with licensing in most of the cases. Now, when you look for your acquisition of IP, what is the first thing that should come in your mind is how strong is the target IP? Do you really want it? And what benefit does it do to you? Okay, that's the overall picture. When you dive deep into it, you have to see who owns the IP. Is the ownership clear or is it licensed? Are there third party users? Are there pending litigations? Are there pending oppositions in the IP offices? Or could that be rectified? Or there are existing infringements of your IP already? What kind of license agreement you want to get in? What are your security claims? And never ignore who are going to be your competitors. See, this is not a process of documentation or improving your CV. I'm talking here where, there are lots of money at stake. It's a business decision. So, how do you go about? The goals vary. If you are buying an IP, what is expected is that you understand the business. Okay, the target. Your target is that IP which you want to buy or you want to acquire. You understand the business. You look into the assets and liabilities. You look at the purchase price, and negotiation is always welcome. Whoever buys it always wants at a lower price. Whoever sells is always wanted a higher price. I mean, that's no different from the way you buy vegetables. Okay. And then finally, you reach to a consensus where you have a value, and you can put a dollar value to it, and then take it across the way you would like to proceed. So all that, sometimes I'm not saying that it's right or I mean it's the way it goes. It is that there may be liabilities, there may be, mm, pending litigations, there may be anything. But what's important is that when you acquire that IP, you are conscious about it. You know about it. They're not some, flimsy sudden surprises which comes up like a fairy tale tomorrow, mm, and hits you where it hurts the most. When you are on the other side of the table, you're like, mm, you are selling your IP. You have to understand your acquirer. You have to try every means to increase the value of your deal. The more you get on the deal value, is the more you can make, is more on your uh, you know, earnings. Now, how to start? Without any confusion whether you are this side of the table or that side of the table, it doesn't matter. You have to do an NDA, a non-disclosure agreement, and find out what you are trying to protect, what you are trying to sell, what are the rights, what are the termination clauses, and who's receiving what during the discussion. Followed by an NDA, you need to do, I mean, what's the normal procedure is an IP audit or a due diligence. I would not like to buy your IP or license your IP if I have not done a proper due diligence. Okay. So, what's the IP? What's contributing? And what are the risks? What are the liabilities? I mean, what are the license issues? I need to know all that. Okay. So IP transaction, there are operating companies, there are non-practicing entities, then you have trolls, okay, you have aggregators, so on and so forth. I mean, this may not sound that the big, but in practice, it has been observed the larger portfolio gives you bigger muscle power. When you're trying to sell or license, you know, a single patent or two patents or a portfolio of patents, of course, the portfolio has a higher value. Okay, and the so larger value gives you more muscle power, gives you to establish more internal licensing teeth. Okay. What are the common issues? Transfer information, valuation and compensation, allocation of liabilities and risk post. What are the termination rights? Often ignored, but the most important is that when the agreement of the license terminates, what happens to the IP? And if there are any required or essential remedies. So, what's the key to success? Now, this is just an overview of that. What's the key to success? Is you demonstrate what's your clear value, try to understand the portfolio in larger detail, and make your claim charge properly, mm, prepare your licensing needs, and look at the budget and what could be your possible competitions, and so on and so forth. I would like to stop here, okay, and look at what are your questions. Okay, Rahul, shall we get into question? Uh, I don't think you're audible, Rahul.
Yes, now it should be fine. Huh?
Hmm.
Yeah, usually when you speak and there's a lag in YouTube, huh? So there's like 15 to 45 seconds later, people. So I think that in the chat we will start having some questions. Already there is one, Dr. Swati Joshi. How IP should be valued? Any specific method?
Well, this is a very interesting question, because there are several models available how to value. So finally, you can't say that I have a great IP, it's immense value. You have to put a figure to it. Now, the most popular method is the cost method, how much you spend. Then there is a market method. Then there's a projected sale method. So these are models which are interesting, and I would suggest that one should take the help of more than one models, hmm, so that you get to a more meaningful conclusion. These models are available. You have to you start with certain assumptions and then try to get a numeric value to that. What is Amit saying? Hmm. What are the best strategies for licensing academic innovations? How to bring more seriousness?
Mm.
Hey, hi Amit, I hope you're doing good. See, the thing is, uh, there is a difference in functioning. Okay, let's accept it. When we look at industrial research and academic research, there's a difference of approach. Most people who work in academic research are very temporary and they move out. It is the job of the supervisors and the PIs to take that forward. Now, the question which you say is that what is the best strategy? The best strategy is same as everybody else. And what is that? See, if you want to sell, you know, see, if I want to sell, one basket of mangoes to you, I should know that you want mangoes. If you don't want to buy mangoes and you want to buy guavas, then I mean, me approaching you is a foolish endeavor. So I should know who needs this technology. And how do I know that? It is true. Yes, a proper competitive intelligence search, there are so many search tools which are available to see who are the people who are involved in it and approach them in a manner that, you know, mm, that I can fill in some of your gaps. See, I will not see. I would, as an industry guy, I may not like to, show interest in your IP unless it fills in some of the gaps which I am facing. In today's world, it is so easy to find that out through patent search and even non-patent technologies, document search. That's one of the easiest way. Now, how to bring seriousness? See, how to bring seriousness is that, people get serious just before the exam. All students get serious before the exam, no matter what kind of lifestyle they lead all through. Now, when you want to do that, it is a success story which brings seriousness to others. It is a success story. So you can do research, you can do basic research, you can do industrial research. If it is of no use in the today's business, you might be just happy to publish papers. If you have an IP, then you have to be very, very conscious of what are the business requirements on this, and approach people who are in the same domain, who are in the same field, and can really benefit. That's your negotiating power. So the next question, anybody? Vijay, Satyaraju, CSR,
There's one from Darbha Shastri. Is
take
it
it.
true potential IP valuation that counts, or is it influence on share market?
See, I mean, this is a very complex question. When it being in share market, you're talking about equity, okay, where the share market, where the NSE BSE, is a controlling factor. Now that happens only for big companies. Okay, big companies are listed in the stock exchanges, and the stock market does influence that. It does get influenced by that. Now, big companies are not usually available for selling their IP. The more is the smaller companies, the startups who build something, and want to really quit by making some money by selling their technology and IP to somebody of mid size or bigger size. So when that happens, because most of them are not listed in the stock exchange, there is no influence of the stock market. Okay. Now, what's important is you get to do some mm, proper due diligence and get. See, I will tell you something. Vijay can wait. What's that? Is when you do a due diligence, you know, the the easiest thing is on a technology, try to put red and green flags in the technology. The green flags are okay for you. The red flags are not okay for you. And when you're buying or acquiring an IP, try to get maximum red flags and use them to negotiate to get a comfortable pricing for buying. Okay. See, IP negotiation is is not as simple as normal commodity negotiation. Sometimes you have to do due diligence. Sometimes you have to get into to see the POCs whether they work. And uh, I have seen, you know, mm, finishing negotiation in half an hour and taking 8 months to close a deal on IP acquisition. So it depends on who is the party, what you're organize, what you're trying to look at it. Let's get back to the question. Vijay, you're saying something. CSR patents are industry oriented, but still more than it. Ah, Vijay, you are doing a survey with all. I know because see, Vijay works in is with the Manipal Institute of Higher Education, and we collaborate on certain things. Uh, so you really think all the patents which the CSR publishes or gets are industry oriented? Not all. If they are, industry will take them up like anything. If they are of any importance, it solves a critical issue of an industry, they will be picked up by industry. There are multiple patents which are which are important to several industry domains, which have originated from CSIR. I would say, like CSR Institute, like I can mention at this, like NCL, IICT Hyderabad, DRDO Lucknow. Now, that doesn't mean others are not working. I'm more familiar with these. Mm. They have come with so many industry projects, have done well, and their technology has been absorbed in multiple industries. But if your patent is valuable, it will be picked up. Its valuable is a overall industry domain conclusion. You think it's important because you did industrial research is a perception. That may not be a reality in the commercial world in many cases. Okay, so what do you have something more?
Yes, sir. Recipe. Okay, I think it's a patentability question.
I am not food technologist, but I prepared one recipe. Okay, see, when you look at patents, there are several types of patents. Okay, one is a product patent, the other is a process patent, the other is a method of use patent. This is the normal nomenclature. If you get to ICT, then you have a method patent and a system patent. Now, what you say is a recipe is a process. Okay. According to the Patent Act of most of the countries, you can always patent a process. So if you have a recipe which you think is worth patenting, and it qualifies for all the patentability criteria, like novelty, utility, industrial application, non-obviousness, etc., you can always get a patent. But the challenge is going to be somewhere else. You know where? Nabi, the challenge is going to be, how do you monitor infringement? Okay, you're going to make this patent, and see, the patent documents are all public. And if I use your recipe and follow that and cook the same dish at my house, how are you going to monitor it? Now, you will not be bothered because I am making it for my own consumption. You will get bothered if it is a commercial use, somebody is using your recipe to make money. Hmm. It's very difficult to monitor, but in as per the law, statute, theory, you can get a process patent on your recipe.
Yeah. We have one question from Sai Datta Vamshi. He's saying, isn't there a lack of clarity, certainty in Form 27 filing and commercialization of patents?
See, this is a very, Sai, I feel you are a practitioner, so you got the pain of Form 27. What's Form 27? Form 27 is a form which you need to file every year, okay, and showing the utility or the usage of the patent, because the Indian Patents Act, this is all these are all Indian Patent Act. The Indian Patent Act also says that if you have got a patent and you have not used that patented process for 3 years, then it can be open for licensing. Okay. And if there is an issue on licensing, then the interested party can approach the patent office for a compulsory license. Okay, that's a far-fetched thought, but that's what the statute and the law provides to every Indian citizen. So you need to disclose what you do. That is, in a way, sometimes you feel, I would agree and disagree both, because I agree because that goes against the philosophy of patents. The philosophy of patent is that, it's not getting a monopoly, it's stopping others from using. And then, that's where I agree. Where I disagree is that if you're not utilizing a patent, see, your patent may be a very not so important or a trivial patent. Think of a situation where I have a patent for a life-saving drug and I don't manufacture it. It's my choice. Because I have a patent, nobody else in the country can manufacture it. You getting me? I have a patent, I don't make the product. It's a life saving drug or a life saving, invention. I don't make it, so it's not made by me. Nobody else can make it because I have a patent. And it's the country and the citizens who suffer. These provisions are actually built in with those situations in mind, which are not common, which doesn't happen every day. Can we move on to the next one?
Yes, let's see. Is there any helping guiding available for individual inventors in the process of selling licensing, or any channels, or maybe I think they are asking.
So the question is, uh, see, there are accepted, recognized help for uh, getting an IP, filing a patent, going through it, and with subsidies. Now, whether you're saying selling and licensing, this is called IP brokerage. Okay. IP brokerage, there are firms and companies who do that for a living. Okay. Now, IP brokerage is no different from getting a tenant for rent for your house. So it's a technology which you want to license out, which is similar to the house which you want to give for rent. So there are IP brokerage companies, multiple of them exist. You can approach them with your portfolio and ask them to find a proper guy who would like to license your technology, and then agree on the commercial terms and go forward. Let's move forward.
Yeah. So Dr. Swati Joshi, she's asking which is better, licensing or tech transfer? Should we create our own company for selling the technology or giving up the rights to someone?
It all depends what you want, Dr. Swati. What you want. Okay. When you build a house, it's your choice whether you want to live in that house or give it for rent or after 2 years sell it. It's your business wish. I always give this house example. When you build a house, you're free to stay at it. You are free to give it as a rent. You're free to mm, sell it after some time. It's your choice. Now the same thing, just remove that house and bring in your IP there. License is nothing different from renting. Assignment is nothing different from selling. It's your business model which you want, and there is no answer for this. In certain there is in certain situation maybe licensing could be better. In certain situation, assignment of IP could be better. Okay. Tech transfer is something which usually in current world doesn't work without assignment or without licensing. I cannot transfer a technology if I don't give him the license to use it. So tech transfer is usually goes hand in hand with licensing. So it all depends. What's your business plan? What is your future, way of revenue plans, and take a decision like that. I hope I could answer your question.
Let's take a few more questions, maybe one or two. So, can a criminal case be done to infringer of a patent?
This is a very, very basic question about patents. You know, when it's trademark or copyright, you can go for a criminal case. When it's patent, it's a civil case. That's how the law and the statutes are. Okay. So what happens if there's an infringement? Okay. If I infringe your patent, what can you do? You can take me to the court, prove an infringement. Okay. I have to pay damages and penalty. This is a civil case. You cannot put me behind bars. But if it's a trademark or a copyright case, you can actually put me behind bars. Not in the case of patents. That's how the statute is. Because most of the time, uh, the patents are owned by legal entities, not individuals. They're owned by organizations, where this kind of remedy works much better than the other. So, do we have something from Rajiv Patel? No, this is Rajiv Patel. Okay. Anything else?
Maybe one last question. Let's see.
Sure.
Defense equipment, defense use equipment, can we patent? Rajiv, okay, this is okay.
There's another question from Rajiv. Can we patent defense use equipment? I guess you know the answer. This is section 6 and 7 of the Indian Patent Act. The answer is you can apply for a patent. It is evaluated by the patent office and the ministry. And if it is of importance of national security, You can't, otherwise you can. So, if you look at Section 6 and 7 of Indian Patent Act, which talks of defense, security, atomic energy, and which are involved with the security of the country, if you have an invention which involves all of these, then it will be evaluated by the respective ministry, and if it's of not of interest or not of damage to the country, you can have a patent. Otherwise, uh, and your application just gets lost in the patent office.
All right. All right. Great, sir. Thank you so much. Everybody is writing thank you. So loads of people writing thank you. Thank you, everyone, for being here for this session and for the excellent 4 sessions. I think that we went through all the sessions in a quite a logical way. I think Dr. Hemang Shah was talking about to do research that actually leads to commercialization. Okay, how to select research projects that actually lead to commercialization. Then we had something on geographical indications, and now we heard Dr. Anindya from NALSAR University of Law regarding IP transactions. So great, thank you everybody. Thank you, sir, for giving us your
Okay,
gift of your
very
time.
much. Thank you very much. It's always good to be present in such situations. It's been very enjoyable, and if it's been helpful to some of the people who join, uh, that's what makes me happy. Okay.
Thank you,
Thank you.
sir. Thank you so much.
Have
Have
a
a
great
great day. Thank you. Yeah. So, folks, we are going to break for lunch. So there is a program schedule that you can download from the description of the YouTube video. There are slight changes to the program schedule. Dr. Purushottam, he will not be able to take his talk. So so I am actually filling in for him. I will conduct a talk on patent strategy, and that will be at around 1:45 p.m. I'm going to start. So during the lunchtime, we will run some music in the live stream, and there'll be some banners. You can check out some of our courses, and I'll be here if you want to ask any questions from me. I'm going to stick around here for around 10 minutes. So feel free to ask me any questions. I will be there answering your chat. So answering any questions regarding courses related to Turnip. We have several courses on patents. We have several courses on IPR, innovation, entrepreneurship, and so on. So please feel free to write even on the chat if you're interested in something and if I can provide more information. So thank you everyone who's writing. So Dr. Aruna, Gopal Venu, Sarika Pawar, Shalaka Deshpande, Sukumar Devnath. So thank you. I really appreciate it. And I will put the lunch banner now. And yeah. Yeah, Rajiv R. Patel, thank you. Welcome, Verba. So please see you all in some time. From 1:45, I will be taking the session on patent strategy. So the stream link will be the same. During this time, we will be running some music and running some lunch break banners. So feel free to stick around on the live chat because someone from our team will be there to write answers to your queries. So yeah, so we are around. Good afternoon, everyone. Great that so many of you are still around. Let's wait for 2 more minutes. Let other people come from lunch. We had 364 people who were live at the same time. That was the highest number. And we've got over 1200 chat messages. So a lot of action going on in the chat. But most people are just writing their names on on their institute names in the chat. So yeah, please, we'll be grateful if you write relevant questions and write something that enables discussion, because that's what this YouTube platform is, best at. So I'm here because Dr. Purushottam, he could not make it due to some unavoidable circumstances, and I'm going to speak on patent strategy. So I have an old PowerPoint deck that I used to speak on patent strategy, and I hope it will be interesting for you. So yeah, we are now live for 3 hours and 40 minutes. I can see this live stream is going on, and still we have 100 plus participants. So hopefully there will be more, but I think I will start my presentation. Great. Let's start a bit. So first we look at the foundation of the patent system. I'm sure, can anyone tell on the chat that how are they experienced already in the field of patents or not experienced? So just write two options, like experienced or not experienced. So that I know like how much, because I know that so many IPR awareness webinars are going on, and most people are already well versed with the fundamentals of patents, how much duration it is, what are the criteria with which you can obtain patents, and many other things related to patents. Niranjani Vijay Kumar, yes, okay, great, you are waiting, and yeah, we can start. Yes, experience, yes, Dr. Paramasimam, yes, all right. I have attended IPR webinar. Many of you have attended IPR. I have worked on patents. That's great. That's what I hope, that even if you are experienced, I hope something in this presentation is new for you. That how we can have a structure around patent strategy. Like all companies are not the same, all products are not the same, all industries are not the same, people are not the same, and hence there is a need for IPR strategy or patent strategy. Great. So let's start a bit with the basics. So the foundations of the patent system. So the patent system, we have to understand about the foundation if in order to understand the strategy aspect. The very foundation of the patent system is actually based on privileges, monopolies, over trade. Okay, if you see the 17th century British patent system from which the modern patent system is said to be derived, earlier it was not related to innovation or technology. Okay, it was related to the king. They used to grant patents as a monopoly to their friends or to their family, or to people they knew. Okay, and only those people can carry out trade in a certain in a certain thing. For example, spices. So they would award a patent to only one company or only one entity to do trade in spices. So someone else will do trade in leather. Someone else will do trade in something else. So this way, it was inherent to the patent system is monopolies over trade. So you can see there is no word innovation in this slide that you are seeing. There is no word innovation here. Okay, so innovation came later. Okay, because then because uh, we had to find a way to avoid to grant these patents in a fair way. Okay, so a lot of people want patents, but if you want to be fair, then innovation was something that was considered to be something that, okay, this is a fair way in which we can you innovate something, you produce something good, you make it known, and hence you will be able to get a temporary monopoly. So nowadays patent monopoly is not permanent. Obviously it's a temporary monopoly. That means for 20 years from the date of filing you have the monopoly, and after that it's in public domain. So by definition, it is about trade and monopoly. The reason I'm emphasizing is because patents are a means to conduct a profitable business. Okay, this is the central theme of IPR commercialization, right? Of course, when we are in an academic institute or when we are doing our job as a researcher, we just think about patent as something we need to file, something that we need to get credit for, and something we can become famous with as an inventor. But in reality, if you see the biggest companies in the world, they have such huge patent portfolios. Volkswagen has 50,000 patent families in their whole portfolio, which is insane. They even have maybe 3 lakh patents in total, because it is a means to conduct a profitable business owing to that temporary monopoly that we just discussed. And that is why it is central to patent strategy and it's central to IPR commercialization. Patents are a sign that show that the patentee means business. Okay, the reason why it is a sign is because patents are costly, right? If you want to get a patent, you not only have to do the hard work of inventing something new, fulfilling the patentability criteria, but you also have to spend a lot of money with attorneys, getting drafting, patent office fees. If you want to go international, there are further fees for going international. So why would someone spend all this money? The only logical reason why someone would spend all this money is because they mean to do business. They are serious about doing business. So if you see a global patent family of a Samsung, say Samsung invents something new in a smartphone screen, okay, and Samsung is patenting everywhere across the globe. It goes without saying that that technology is really important for them. That is the way they want to really do business with that technology, and only that is the reason why they are spending so much money in filing in international patents. All right, so moving on. This is the patent filing trend. I show this in my slides just to re-emphasize to people that patents are actually very closely related to the economic growth of a country. So if you see, the Japan line is green. The green line is Japan. And since the year 2000, actually, their economy has been under recession. So that can also be seen in the decline in the patenting activity. US, which is the purple line, it has been growing steadily for the last 40 years. Okay, they are showing consistent innovation. So their society, their economy is built on sustained innovation for over 40 years. And that is why, folks, you and I, we are here. The reason why you are and I, we are here is because the Indian government, the Ministry of Education, they are, encouraging institutes to file more patents, to get more aware, because innovation drives society forward. Things that you innovate now will, lead to products in the future. And that is a way to improve the GDP of the country and to improve the livelihoods and the quality of life of a country. So you can see China. Okay, this is quite a growth. If you see, in 2012, they became the largest patent office. They even surpassed the United States in terms of the patent filings. So that's like a lot, right? They're filing 1.5 million patents every year in today's time. So that also reflects on the growth that China has seen, especially in the last, say, 20 years. Okay, even a bit before that, but especially the growth has been phenomenal in the last 20 years, so since 2001, 2005. So yeah, that's the reason why we are here. And because, and also this also indicates the previous thing that I said, that patents is a means of doing business. So this also shows you why there is so much demand for patents. Why so much? 1.5 million patents are being filed by China. Why? Because it's a means of doing business, and it's a means of profitably doing a business, to do business with profit. Not just do business, you do business with profit, because the monopoly ensures premium pricing for your products. This is the situation in India. The last financial report, these are old slides, I think. 56,000 was the last annual report by the patent office, that is per year filing in India. And but according to the unofficial updates, there is 62,000. I think in 2022, 62,000 patents were filed in India, which is a good 10-11% growth rate that India is seeing, which is quite good. 10-11% growth rate is decent, with which India is growing. But what is more worrying is that, of course, this is a very low number, 50,000. If you think 50,000 patents for the whole country, which is, we are a big country, and there are more than 50,000 institutes, academic institutes in India. Even if they file just one patent every year, we should reach this number. And then on top of that, there's a huge small medium size industry. There's also like multi-industry conglomerates, really big companies, government research organizations. If you combine all of them, and then you think that the total number of patent filings is 50,000, that does appear to be very, very low. And out of this 50,000, what is even more worrying is that you can see these are the top filers of India. I will just full screen it. So these are all foreign companies. If you see Qualcomm, Samsung, Huawei, Ericsson, Philips, Robert Bosch, General Electric, all these are foreign companies who are filing in India. So even if you think from this 50,000, 2/3, that means 33,000 patents are being filed by foreign entities in India. And ourselves, like domestic entities in India, we are filing only 17,000 patents per year. So even less than what we had been thinking. So please, if you have any questions, write on the chat. I'm seeing the chat as I speak, so I can take some questions. But yeah, I also again want to emphasize, please don't write your institute name in the chat. There is no use. We are not tracking it, and yeah, it just creates spam for relevant comments. So yeah, these top 10. If I show you that CSIR is number 14. CSIR is the top filing entity in India, and they're number 14 on this list. So they are not even in the top 10. Indian entity is not even in the top 10 of patent filing companies in India. So, all right. So why patent strategy? So why a patent strategy is needed? So first thing why you need a patent strategy is because patent is a negative right. I'm sure many of you have come across this. It simply means that although you get protection from infringement, when you get a patent, you get protection from infringement, but that is not, somebody will not come and protect you. You only have the right to exclude others. That means if you find someone infringing on your products, then you have to take action. You have to monitor it. No one will monitor it for you, and you have to send lawyer letters to them, or sue them if needed, or just send some friendly letters, and so on. So you have the right to exclude others from producing, offering for sale, importing, using a protected invention. Okay, that's why one thing is simply why you need patent strategy, because it's a negative right. You have to be on the lookout. You have to do monitoring. You have to check patent databases. Big companies, they have a team of patent analysts who keep looking at new patents which are being published. Okay. The second reason why you need patent strategy is because patents are a costly affair. There is like easily, if you are an academic institute, you would spend maybe 80,000 to 1,50,000 in filing the one patent. That is like complete professional fees, patent office fees, and all the overheads. So that much expense you have to go through for filing just one patent. And for companies, big companies, even they hire the best law firms, their filing rates can even go above 2-3 lakhs. So that's like an upfront cost, but there's also a recurring cost. If you see, the recurring cost keeps increasing as you hold the patent. So if the patent is valid for 20 years, So the cost of maintaining a patent keeps going up. That is also there in the Indian Patent Office. Many people don't know that for the first 2 years, if you renew a patent in India, that is 800 rupees. That's the annual charge for renewal. But in the last 2 years, that means around the 17th, 18th, 19th year, you have to pay 8,000 rupees per year. So 10 times increase in the renewal fees when the patent is ending near the end of term. So that is simply because the patent system doesn't want you to hold monopoly rights for nothing. Okay, so they want, if you're only very serious, only then they are wanting you to hold the monopoly rights. That is why many patents are abandoned, because just the cost of maintaining the patent is not worth the amount of business that the patent is generating, or the total amount that the patent is worth. So that is also one reason why you need patent strategy, because just to manage these costs, just to manage these life cycle costs, and to make sure that they are less than the profit that you are able to make with patents. Sachin Sharma, can patent filing be done jointly or individually? I think it can be done both ways. So yeah, it should not be a problem. The third reason why you need patent strategy is because patenting is a long life cycle. Okay, innovation is not a one-day game. Innovation takes many years for it to achieve a critical, value stage where a lot of people can benefit from it. And this is also shown in the nature of the patent system. The patent system is not very fast, and there are also some reasons why it is not very fast. It also shouldn't be very fast, because you cannot hurry in, because patents are closely related to the market. Some market validation and technology validation goes hand in hand, and that takes time. So if you see here in this picture, from patent priority filing to grant, even approximately 4 to 5 years is typical. They are saying that it's getting less and less, but if you take the averages, it's on the higher side. It's on the 3 to 5 year side. It's not rare also that sometimes patents take even more than 5 years. So because of this life cycle, you need to take decisions. You need to pay fees at regular intervals. You need to file follow-on patents if some new improvements are being made in your technology, and you also need to manage the costs. You need to monitor the market. You have to assess the market, and based on that, take those decisions. So because it's a long life cycle, there is a importance of patent strategy, and that is why big companies have a lot of people working in their patent departments. Patent rights are territorial. So simply, if you need to have a strategy. If you want to go global, you need a strategy. Which countries you should patent, which countries you should not patent, how to save costs. So all these are decisions that need to be taken based on the context. And again, it's a part of patent strategy, why you have to look at IP in a more holistic way. Okay, not just that you have an invention and that you need a patent. Because IP rights may not be respected in the same way as in your country. Okay, the cost of filing international patent can be really high. Where you want to patent is a decision that becomes important. And again, an Indian patent will not give you protection globally. There is industry variation. So can you please write on the chat, like, in which industry do you think patents are most important for success? Okay, software, pharmaceuticals, electronics, manufacturing. Just write on the chat what the answer is. So there are inter-industry variations. So all patents are not same in all industries. Okay, so I'll just take maybe 1 minute break, and you can meanwhile write on the chat what you think as the answer to this question. In which industry do you think patents are the most important for success? Pharmaceuticals. Yes. Everyone is writing pharmaceuticals. Yes, that is true. Can also someone write why? Why pharmaceuticals? Yeah, it's true. I was in a conference in which country, I don't remember. It was in Vienna, I think. I was at a conference in Vienna, and Novartis, head of IP of Novartis, one of the biggest pharmaceutical giants in the world. He even said that the whole department can be eliminated, like a whole department can be fired or dissolved if they don't have a good IP report. So they have a yearly IP audit for each and every department, and if the department is not performing well in the IP aspect, uh, that whole department might be dissolved, and people put in different places. So yeah, pharmaceuticals is true. It's really important in doing business, and yeah, some reasons can be that pharmaceuticals is very it's like a one patent one product kind of a in industry. If you think about electronics, uh, smartphones and all, there are so many patents in one particular device, in one particular product, that it becomes kind of a complex product industry. And because of that, the value of one patent actually goes low. But in pharmaceutical, it's a one product one patent industry, so you can have just one patent for a very, say, an important molecule that you've come up with, and that is an integral part of a drug. So you can just basically patent the whole drug with that. And so that is one thing. And of course, identifying infringement is also easier. Okay, you can easily check the composition of drugs of a rival product and just find out that whether they are infringing on you. So because of that, it becomes even more. So that is again part of patent strategy. I think some speakers also mentioned it earlier, that uh, how easy it is to identify infringement. If it is easy to identify infringement, then you should get patent protection, because in that way you can easily exclude your competitors. Yeah, the composition is critical. Product process patent, yes. Life-saving drugs with inventive formulae, yeah. All, yeah, it's profitable. Yeah, drugs are profitable, and also patents also have a long life cycle, right? So patents are getting granted in 5 years or so, and then you have protection like up to say 20 years. So pharmaceutical products actually fit very well. If you see the life cycle of innovation in pharmaceutical, first they do research, but then they have to go through a long approval process. There are a lot of regulatory approvals, trials they have to do, different stages of trials. So for a new drug to be really hitting the shelves on the medicine shops, it can even take 8 to 10 years, and that coincides well with by the time when the patent is going to be granted, and then they'll be able to enjoy the protection for the following years. But in complex industries, like if you see ICT industries, it is difficult to, the product life cycles are very short. Even a new product can come and it can become, like not so useful after 5 years, because another product can replace it. So the life cycle of a product is also an important factor in terms of gauging when patents are really important and when patents are not so important. So yeah, correctly mentioned by the audience, thank you. The right answer is pharmaceuticals. So it's one of the most important to have patents. If you see pharmaceutical companies, they live and die by patents. And it is not all evil. Okay, it is also an incentive for pharmaceutical industries to do research on very difficult things. For example, they are saying that many pharmaceutical drugs, up to 30%, pharmaceutical drugs, they would not have been on the shelf of your medicine shop if there was no patent system, because pharmaceutical research requires long life cycles and a lot of heavy investment. So why would someone make all that investment, take all that risk, if um, if there is no return in the future? Okay, so that is also why patent system helps or encourages many pharmaceutical companies to have long range kind of planning and develop drugs that will be helpful in say next 10-20 years, and make those investments. So they are incentivized to make those investments uh, in because they think they can get future profits from it. All right. So this is a stages of technology development. Actually, it also depends your patent strategy and your commercialization efforts. You know which stage you are in the technology development process. This is a famous S curve. Okay, if you studied technology management as an academic, you would have come across this S curve. Okay, and this, if you see patenting trends, they also follow this kind of an S curve. For a new technology, you would see a very large growth. They will be in the emergence and the growth stage. And for a older technology, they would have the patenting applications would have declined. So you would see more like an S curve. So I'll show you. This was from our IPgram patent database, which was acquired actually last year in 2021. And so technology S curve, if you see wind power, it's a very old industry. Okay, wind power patents, this is the 20-year trend. Okay, so it's following kind of an S curve. And if you see graphene batteries, which is a very upcoming technology, it follows, it's a rapid rise in patenting, and perhaps it will be even more, going forward. So this is really in the emergence and the growth stage. So also this is a part of, say a patent analyst, or in deciding on your patent strategy, which phase you might be in, and take decisions accordingly. Okay, factors that affect patent strategy. So we've seen, all the variations why patents are not, single thought process. There's so many different things to cater. So let's look at some factors in the patent strategy. So this is one very good, picture view of technologies. How you can have access to technologies, and I'll just show you. I'll put it on like full screen so that people can see properly. Just a moment. Yeah. So if you see at the bottom of the pyramid, which is basically publicly available technologies, these are either very old technologies or technologies that have not been protected. So these are a vast majority of technologies at the bottom of the pyramid of the spectrum of technology access. It's like the publicly available technologies. Okay. So this is not of concern to us in this particular, say, IPR commercialization conference. But then comes three different ways in which you can have access to technology. One is cross licensing, which is actually the most broadest of people in the market are able to use these technologies, and a lot of players in the market, they are cross licensing technologies to each other. A very typical example of cross licensing is a telecom industry. Okay, so a lot of equipment providers are there. There's Ericsson, there's Nokia, even Apple is there now. There's Huawei, Panasonic, Sony, like all these kinds of they are making 5G, 3G equipment. Qualcomm is a big player. So they are because their products are such that they are classified as complex products. So even one product can have multiple patents from multiple different vendors. So in order for them to not to keep suing each other, constantly being involved in litigation, they come up with cross licensing agreements. So it's a very good way of making sure that you have so that the vast majority of public can have access to a technology. And then and this is also typical in industries where there are few very big players, so that they are not fighting all the time, but they are in returns cross licensing. So one company's patents can be used by another company in return for, say, the other company's patents being used by the first company. So this way, that is one very common way of accessing technology. So if you are in this kind of an industry, likely you will have to have cross licensing agreements where there are multiple big players, and you don't want to always keep fighting. The most typical way is actually licensing. Many manufacturing firms are using this kind of a strategy, and even individual uh, inventors, they go through this licensing route, that they are able to sell their technology to someone who has the ability to produce, or who has the distribution. So it could be that if you are a small inventor, your product might be great, but you do not have the production capacity, or you don't have the market distribution. So in this case, it is likely that you will have to go through the licensing route. And finally, the exclusive access to technologies, which is like you can say a company like Apple. When you own the vertical supply chain of the technology and the access, you are basically come in this stage where you are able to own the access to the technology. And because you are so powerful with the market and the distribution, you are even able to produce yourself, and you are even able to distribute it to a vast majority of the market, so that you don't need to. So yeah, sorry, I'm getting a call. So uh, this is the spectrum of technology access, and these are the areas where you have to. These are the areas which you have to think about. These are the questions. So I'm not giving you any answers, but I'm giving you questions that you have to think about in order to decide what strategy you should follow. Okay, is the technology easy to copy or not? Are there too many competitors? Is the technology cutting edge or just general mix of different technologies? Do you have distribution capabilities? Do you have manufacturing capabilities? And is it the market a niche market or it's a wide market? So these are some questions that you can think about when you are deciding on what IPR strategy to use and which part of the spectrum you belong to. All right, factors that affect patent strategy. I think we are not much on time. So if there are any questions, abandoned patent versus granted patent in other countries, any info? Let me go through my slides. Let me see if there's anything. Yeah, these are some things that I've already told you. So these are some more questions that you can consider. So is the product life cycle long? How easily can the product be substituted? Is the innovation cumulative or radical? What creates the most value? Is it the patent, or is it the people, or is it the data? So what part of the innovation is the most valuable part? In pharmaceutical industries, it's the patent itself, but in other industries you need a lot of complementary things for a patent to succeed. You need people, you need distribution, you need machines, you need all kinds of other complementary assets have to come and provide value to the patent. So in that case, the patent is not that valuable, and you will have difficulty in selling those kind of patents. And the nature of the production process, and is it a one product, one patent product, or is it the one product, multiple patents format? So which we already discussed, pharmaceutical industries versus the ICT industries. Okay, can the patent be relevant to a technical standard? So these are again some more considerations. The distance between fundamental knowledge and its application. So if the stream of science is very, very new, okay, so that means most of the patents are fundamental knowledge. That means it doesn't have proper application areas. So you have to consider, usually in scientific patents, this might be the case where your patent is too close to the fundamental science rather than the application of the science in a certain product, or the market is not up to date with that kind of a technology, or it will take some time for the market to become like that. So distance between fundamental knowledge and its application. So academic institutes have to think in this regard how they can, because if their patent is likely not creating value for their buyer, then how can they sell the patent? So maybe the buyer just needs to get a huge patent portfolio. They want to show a huge patent portfolio to an investor to gain higher valuation, or they want to show a huge patent portfolio to as a threat to some competitor that they can sue. So there might be other reasons why a buyer might be able to buy from you. Size and nature of market, nature of competition. Again, in telecom industry, we saw that the nature of competition is different. So accordingly, the cross licensing is the most important way. Nature of R&D process. Is it capital intensive? Do you need a lot of uh, upfront investment? And the size and nature of market. Okay, it's repeated. And are there any government regulations that can cause many years? So, all right, let's continue. Let me see if there's any question. Let's, take some questions. So let's see. By the way, we are just 10 minutes from Dr. Prachi Pandey's talk, so I don't want to take too much time. Are the changes of renewal and maintenance similar in other countries too? Yes, yes, yes. It's always increasing. So they are discouraging you to renew your patent, basically. So basically, only patents that are providing value to the owner, only they will be maintained to the full 20 years of the duration. So yeah. Is if an innovation is possible over an already patented product or process, how should be the IP strategy? Already, you have to. I mean, you have to go substantially over, right? There is a non-obviousness thing in one of the criteria of getting a patent. So if something is already patented, you have to prove to the patent office that what you have added to that already patented stuff is not some child's play, or it's not some average person can do it. Some really a lot of effort by a technical expert is needed to come up with what you have developed. So in that way, it's fine. If you can get your own patent, you're able to stand on your own, then then you have a new patent, and that's fine. Let's see. Abandoned patents versus granted patents in other countries. Any info? I don't know what you are exactly asking, so I'll pass this question for now. Dr. Swati Joshi, sir, for some secret formulas, people are not filing patents. Yes, because the information is public everywhere. Is there any way to solve this problem? Yes, typically trade secrets are very, very important form of IPR. So in trade secrets, it's a different actually conversation, but trade secrets are important. And actually there is in Delhi High Court, even a judge was saying that every week one trade secret case is coming. And that means we don't see trade secrets. It's not publicly available, so we don't discuss it. But actually, trade secrets are a very important form of IPR. So beyond patents, you have to consider trade secrets. There are certain things there are certain things in trade secrets that you have to make sure that whatever your recipe is, whatever your secret formula is, you are making a lot of effort to protect it. Okay, if you are not making any effort to protect it, and if by chance it leaks to the public, then you will not get protection. So you have to show that you're making efforts to protect it. And the other thing is in trade secrets is that that secret formula is valuable to you because it is secret. Okay, so that's again another check for trade secrets. So if your formula is, you know it's as good as a public formula, then in that case maybe the trade secret is not so valuable. But yeah, I would suggest that you read about trade secrets and accordingly devise an IP strategy. All right, Bala Gopi, how to retain the granted patent after this period? Well, you cannot maintain a patent beyond 20 years, but there are strategies. One strategy is typical in pharma industry is called evergreening strategy. So they try to evergreen an invention. For example, if there's a pharmaceutical drug, they will, get add-on patents to that. For example, the new version of the drug, it digests faster. Okay, so that can be a significant addition. But some countries are, not accepting this kind of extra extra subject matter. But yeah, but these are some ways. Innovation keeps going on. In order to maintain your leadership position in innovation, you have to constantly innovate, and that is what the patent system also uh, is there for. Dr. Amit Kumar Tiwari, thank you so much. Thank you, really appreciate it. In FTO searching abandoned, yes, no. In FTO, no. In FTO, you don't search abandoned. You search only the ones which are valid. But in invalidity search, you will have to search everything. In all industries, but I have to choose one, then maybe pharma. Okay, maybe it's just a comment. Okay, maybe final question before we we wait for Dr. Prachi ma'am. Jiva Balu, after patent is granted, what steps are done for licensing? What strategies to be planned? Well, For a patent to be licensed and commercialized, the inventor has to be very, very marketing oriented. So I believe that marketing is a thing that is very, very low in academic institutes. People don't write enough cold emails. People don't make enough phone calls. People don't go to enough networking conferences or trade fairs. And people just don't approach institutes like NRDC and other institutes or other technology incubators where, they increase their chances of demonstrating their technology and finding a licensee. So I think that the strategies that you're talking about, strategies is a very big term. I think what you need is passion and what you need is marketing. So these two together, they can help in commercializing in inventions. Let's see if I have any relevant slides. Motives to file patents. Again, the motives are changing. All patents are not filed to get exclusive access and exclude competitors. These are many different reasons why patents are being filed. And you can actually, I have a course. It's a very low cost course. It's on the Turnip website, 2-week patent course. It's just 297 rupees. And I'm discussing all these aspects, patent strategy, patent analytics, patent searching, very, very fundamental, important things on patents, just to understand patents more before you think about filing. You understand a bit more. So that's like a 2-week course. It's very low cost, so you can think about it. Levels of patent strategy. Maybe this is the last slide that I cover. So different entities will have different levels of patent strategy. For example, if you are a small company or an institute, you are just looking to protect your inventions. That's it. It's one-off inventions. You want to take services from external, say, law firms and protect your invention. But say when you're filing 10, 20, 30 patents every year, then you are at a cost level. Then you have to have, say, maybe an in-house patent agent who is going to organize the filings. Then you probably need a structure where you will have invention disclosures. So all these kinds come when you want to save costs. You have like 10, 20, 30 applications every year. Then there are companies which are actually very big companies, which are actually making profit from their patent portfolios. You can say IBM is one company like that. They actually do active litigation. LinkedIn was forced to buy 400 patents from IBM because IBM threatened to sue them. LinkedIn, Twitter, Snapchat, all of these their portfolios, they're full of IBM patents which have been transferred to them. So this is how they are making. And even companies are acquired and sold based on other companies making active litigation rights. And then finally, there are companies like Qualcomm, where the whole business model is innovation and IP. So when innovation and IP, it becomes a repeatable business model growth. So they are so focused on IP, on selling, licensing, and finding new ways of growing their IP portfolios and generating profits from it, that actually IP is their business model. So they don't have they don't have specific products per se, but you could say that Qualcomm is like that kind of a company. So these are the different levels of IP strategy or patent strategy in companies. Patent litigation, unfortunately, we don't have much time. So I will just keep this slide here for now. And within few minutes, Dr. Prachi Pandey, she'll be with us, and we will continue with the next session. I will share you my contact details so that if you want to talk to me, if you want to write me an email, this is my contact details. So if I will just, so that you can see it's rkapoor@ipgram.in, and there's my phone number and WhatsApp. So I'm happy to hear from you. Great, thank you everyone. If you like the session, Physio GK, thank you. Avinash Kumar, okay, let me see. I'm having a proposal for a patent but not having knowledge about process or for how to file it. Avnish Kumar, it's very typical that inventors are not very well aware of the process of patent, because becoming a patent agent in India, it's a very long process. You need to give a very difficult exam. So there's a lot of learning process. So it's very unlikely that every person can have good knowledge about patent. So please take help from a patent agent. There are freelancer patent agents in every cities. You can just search Google in your area, maybe even there are very patent agents who can help you. And uh, and yeah, please take help, because otherwise you are doing a disservice to your own in invention. Because if you are an inventor, you should focus your efforts on inventing, and let somebody else do the processing part of it. LinkedIn ID. Okay. It's I will write it here. All right. Okay, Niranjani, I hope it helps. Is any fee reimbursement provided by government for MSME? Rajiv Patel, I am afraid I don't know about it, but I do know that there is a lot of government support for patents. In general, the filing fees and anyways very it's reduced for individuals and in universities. But you should talk to some incubation centers. They are usually well connected and they are everywhere. Maybe join an accelerator program if they have. So all these kind of things, you make progress here. So with this, I'll end my session. I want to thank you, the audience, for listening, and we will continue Turnip Innovation Festival with Dr. Prachi Pandey's talk. Dr. Prachi Pandey has taken several sessions with us, so she's a very well-known figure in the academic circles in the patent system. She's an associate professor, and she is the deputy director of Startup and IPR Cell in KPGU Vadodara, and she has a distinction from NALSAR University of Law with A++ grades, and she's a registered patent agent and has more than 15 years of experience filing patents and teaching about patents. And so today she will be talking about how to manage IP assets. So some very important things you can learn from there. So I hope you enjoy the next session. And with this, I will invite Dr. Prachi Pandey to the stream. Ma'am, welcome to Turnip Innovation Festival. Thank you for your time, and the stage is yours.
So a very good afternoon to all the innovators of India. It's great to see you all, that you all have gathered here to learn about the management of IP assets. So I just want to say, because we all are innovators, and day by day we are innovating something, and somewhere we are contributing in the steps towards Atmanirbhar Bharat, that is Make in India initiative. Because what we invent, what we innovate is somewhere very useful for the society. We can make it available to the people at very affordable cost, at a very innovative solution that may not be useful, not only for India but for the world. So if you are innovating something, because we Indians are full of good ideas, we have good potential, we are hardworking, and can really develop our products, our novel concepts into some very useful products. And such products must not be inside some thesis or some publication. Yes, it should be, but along with that, it should have some revenue generation capacity. So for revenue generation, we acquire the patent rights, that's for sure. And there are many kind of IP that support us to protect our inventions from getting infringed. And we also want a monopoly. So why monopolies? Why? Because we have putting so much of hard work, efforts, money, everything towards some inventions to innovate something. So government gives us rights, so that it could be monopolized for some period of time, so that we can ourselves only can produce it. And yes, that is also very necessary to promote the research and development in our society. So managing intellectual property, why this is very important? Acquiring is important, yes, we should get our rights of patents. Our IP assets should be effectively utilized, and the various means through which it could be acquired is by acquiring the trademark rights, patent rights, domain names, trade secrets, industrial designs. Others are like copyright, Plant Variety and Farmers Act, geographical indications, semiconductor integrated circuits. There are many kind of IP rights. So there are many ways many acts, laws such as Patent Act 1970, Trademark Act 1999. So all these are governing some rules and regulations through which the innovations are monopolized, or we can say the rights are given to the innovators to sell the product, import the product by their own names, and can generate revenue. This is a really service to the nation, and for that government has given so much of facilities, like all are at very reduced fee of 80% reduction for individuals as well as for startups, as compared to the normal companies. So in almost all the IP rights, there are lot of discounts, lot of fee reductions, so that every innovator should get a chance and opportunity to apply for the patent and to acquire it. So suppose once we acquire the IP rights with us, then the journey starts. So whenever we have a patent granted in our hands, we have a trademark registered in our names, we have a copyright. So we shouldn't stop there. We have to actually utilize those rights, and those rights must give us some value in future. Otherwise, government may intervene and may say us to give the rights to another, because once we acquire some right, it's our duty to use it for the service of the nation. So one thing is important is like how we protect our intellectual property. So intellectual properties, as we have just seen, patent, copyright, trademark, whenever we acquire it now, the strategy should be to protect it for the future. So we shouldn't infringe others' patent. Others must not infringe our patent. We shouldn't enter the like area of or domain or trademark of some other. Some other must not be. So we should have an independent status in terms of maintaining our IP rights. This is important because to avoid the infringement, to avoid the copying by mistake might be there, not intentional also. And we should have our own rights with us. So patent rights or trademark or copyright, once we acquire, we have a certain period of monopoly of making it, selling it, using it, importing it. And whenever we are infringing somebody, somebody can sue us, or we can also do the same. But what is important? Whenever we acquire an IP right, important is to either use it or otherwise we might lose it. So in terms of trademark, suppose trademark is granted to some person. So the owner have 5 years right from the date of registration to start using their mark. Suppose some innovator has innovated something, their company is registered, but they are not in a position to use it perfectly. Means like suppose McDonald's arc or Godrej symbol, if they are not using it, how to use them? Means like your product must carry such marks, such slogans. So if suppose products are not being commercialized extensively, it may be the situation that innovator might not have used the trademark for 5 years. So in such cases, cancellation action can be taken place, and somebody else can register such kind of trademark in their own name. So whenever we own a right, we should start using it. Otherwise, there are many chances that you may lose the rights. Even after have a patent granted, even have a trademark registered, this may happen. In terms of patented invention, the government has a very strong rules and regulation in terms of patent. Like if you have a patent rights with you, you should start commercializing your product. If it is not well commercialized, if it is not made sufficiently in certain countries, or if it is being manufactured outside India, if you are not giving employment to the people of India by manufacturing your own product, then government may intervene. So if your patent is not working of patent statement is must. That has to be given by every innovator with a patent right. Then in such case, government may give compulsory license to some other company. License means the innovator has to give the license to some other company to make use of their own innovation. In return, they can receive some royalty. So that is the scenario. So in such cases, government may say any other company to prepare the product, and in that case, the formula has to be shared to other firm. So it simply means that once we have a patent right, we should start using it extensively. Trademark has some pros and cons in terms of like somewhere some trademark has a level of distinctiveness, market power and capacity. So Sometimes our very weak mark may become very strong because they are being used by many people. Sometimes mark may become weak because of it become a generic term. So suppose, just for example, this word Xerox. Xerox is a company, but this has become a very generic word. People treat it like go and I'm Xeroxing it or get it Xeroxed. So it's actually photocopying. Photocopying is the correct word, but we use the word Xerox. Xerox is nothing but actually a firm which has a machine first invented for photocopying the documents. So the same way Coke, sometimes we say that give us a Coke in case of cold drink. So it becomes a very generic term. So in such cases, Coke may lose their rights because it become a very general term, iPod in Ferrari. So these are some type of words that have lost its own trademark power, and it has become a generic word. So how to then control all such things? Because if suppose my trademark is becoming generic or I'm losing my rights, so in such cases we have to become our own watchdog. Means like we have to keep an eye on the market, and we have to see that what is other marks are available and are they very similar to our own mark. Suppose my own product has certain kind of logo, slogan, words, or some kind of like symbols to represent our own identity. If somebody is imitating the identity or copying the identity by using the same kind of slogans, marks, then people may get confused either by words or by pronunciation, and they may like get confused like it's my product, but actually it's not mine. So what can happen? Either the other product, if they are not good, they may we may lose our own reputation because people are buying because thinking that it's our own product, but it's not us. So it's important that we have to monitor the market. Who is selling the product? Who is bearing the same mark, same kind of shapes, and how we can lose our reputation. So we have to see the press, social media, website of other companies. So every firm has a special monitoring cell, legal cell, which monitor all kind of products which are similar to us. And in such cases, if it may be there that they are using some marks or some slogans similar to us, we can catch hold them, and definitely there are legal proceedings. So in which through which we can really prevent others. There are many online tools to monitor the market. Google alerts are there. So suppose something is coming which is similar to ours own brand, then it could be highlighted and it could be said to us. So nobody should attempt to take up our own mark. There are many examples like this in such cases. Suppose in drugs also. So what is there? Suppose diclofenac, decamol or diclamol, some kind of words are there. If it is an OTC drug, people can go and buy. So, and suppose the other product is not so good, the first one that was actually maintaining its reputation may lose it because people get confused. So, enforcing IPR is very fundamental. It's a valuable source of revenue. And yes, suppose somebody else has taken the same kind of words as our own product and people are buying in confusion, we are losing our revenue. So we have to be really a watchdog in that. So every company must have a legal section, every startup company especially because they are new and not very known. So in such cases, some really similar products may be launched in market. So where the IP is getting violated, it has to be critically monitored on the sites. Now, what is important? It's like IPR must be registered first before using. We cannot use any logo, any design, any style unless until we register it. So whenever any company or any product is in market, every mark, every kind of their, whether it is a word or it's a mark, something, it must be registered. Their name should be registered. Without registering our trademark or without registering our design, our patent, we cannot launch, we cannot enter the market because others who are already in market, the giants or smalls, whatever, they may sue us for infringement. So it's important that once we make our mark more popular, it become more and more strong. Suppose nobody can dare to copy the Godrej mark because it can be easily identified. It's much popular. Even normal people know how it's a signature mark actually, Godrej, but everybody knows that how it looks. So normally confusion is less. But if somebody had just entered the market, there are chances that similar products should be there. So it's important that we have to be our own watchdog. We have to see what is the currently available drugs. And yes, once we have registered our trademark or patent or design, we should use the word. Suppose this copyright should be like this: trademark, TM, ID, or registered patent. If a patent is registered, we have to write the word registered patent. And we have to see that if such marks are with us, then we are showing yes, rights are with us, and nobody can use that. This is just a kind of warning symbol. And then we have to monitor the market. We have to defend our own rights. And then once we see that somebody is taking or operating using the same kind of products, then we have to fight back. Definitely all the legal proceedings will be in our favor, because we have launched it first, we have the IP rights, so we can easily sue the other party. And if the IPR is registered, any company can easily win a case. So those who have an IPR registered are the owners, legal owners. Important is that for trademark, always use, once you have registered your trademark, use the word TM or R. ID, registered design, registered patent. This word has to be written on the product. And for copyright, which are registered, this particular symbol has to be there. Powerful warning message. This is the powerful warning message. I am the owner. I have my patent registered. I have my design registered. So nobody should use it, first of all. So we are protecting it by giving a warning. Another one very important thing, if we have applied for a patent but not registered, not granted, then we are not supposed to use the word registered, or we are not supposed to use the symbol R. If IPR is simply applied, we can write patent applied, but we cannot use the word registered unless until we get the grant of the patent. Now, important is what? Suppose some trademark, as you all know, what are the trademark? McDonald's name, Adidas, Godrej, all are the trademarks. They could be even slogans. They could be even a word. They could be even a symbol, a picture. Anything could be there. What is important here is like somewhere, suppose we have a domain name. Suppose it's www.google.com or marutisuzuki.com. So this is a kind of domain name that every company normally uses it. This particular word is a trademark of that. So somebody, if they are using some unauthorized use of similar kind of domain, it's a kind of cyber squatting. So suppose I'm using my own company name by some domain, and somebody is taking some words and trying to launch their own domain just to confuse it. So why I'm using some other domain name? Because just to create a confusion. Suppose if I'm using my own domain as maruti.com. So people may get confused that this is the Maruti Suzuki, and somewhere they try to open the website, they try to see that. So I just want to attract the consumer just by confusing them with, by using some of the text of some very popular domain name. So this is called as a cyber squatting. This is a very regular practice in case of like companies which are small and just try to somewhere take up. This is a wrong practice actually. So typo squatting, sometimes you can suppose registering starbucks.org. So Starbucks is a very famous brand, and I'm using this word to create my own website. Yeah, I'm not related to anything which Starbucks sells, but I have just added the word org and launched my website. So people will normally get attracted. Okay, let's see what's inside. So this is a kind of like some kind of confusion creating due to phonetic similarity with the words already in the domain, and they're very popular. So in this way, typo squatting is a major kind of domain, which suppose if not managed well, may lose the reputation of already very reputed firms, or they may reduce the revenue generations too. So suppose these are some examples. We can see gmail.com in place. This is the typo squatted websites. Weather.com, Walmart.com, that was very popular. This is very similar, Walmart.com. So people may, suppose in both are shopping sites. So people may enter this site instead of actual website and may even buy something from this website. So this is a situation where actually they are reducing the revenue of actually owners of the genuine products. So we have to be very particular. This is very important. Amazon.uk.com, Amazon.uk.uk. So this is the actual, but people may be surprisingly using this because this looks more genuine. So it's very important that every, suppose not only a company, even a startup should always think of what is similar to them. It's already in the market. And yes, you can definitely sue them. There are various ways by which it could be there. Some examples more. Suppose Nissan Motors versus Nissan Computer. Nissan Motors, we all know. Nissan Computer is also there. So most people immediately think of cars when they hear the name Nissan. And this is understandable since the company has used the label since 1970. This label is there. But you know, Nissan.com was registered as a Nissan Computer Corporation, and this was 5 years before the automobile company decided that they wanted the domain. So Nishan also wanted the domain of Nishan.com, but Nishan.com was already registered by a computer company. So Nishan couldn't open their own website using this particular domain name. So this is the beauty of domain, that once it is acquired, it is legally accepted by the government and nobody else can use the same domain name, even a big firm. Microsoft versus Microsoft. This is a kind of actually a person, Micro, who has set up a particular company with this domain name in 2003 and promoted his web design services. He had a web design service. And but what has happened? There is already very popular brand of Microsoft. And since the domain could be phonetically confused with Microsoft.com, the larger corporation, that is Microsoft, requested to transfer the domain name. And they offered $10 for the price of the original registration. But Roe, the particular person, demanded this much, $10,000 for the domain. Microsoft sent a cease and desist letter accusing him of cyber squatting. So earlier they tried to settle out. But then the person, they thought that Microsoft is such a big company, they can pay me anything to transfer the domain to them. So in such case, they asked for much more than required, and then Microsoft sent a cease and desist letter in that. So this is how the legal proceedings start. Then Microsoft won the case. So this is the scenario where actually the typo squatting is creating so much of legal cases inside, like India, world, everywhere. We can say Amul. Amul brand everybody knows. Amul is India's leading brand in dairy companies and has a sales turnover of very high. But the company became the victim of cyber squatting. How? Because people have used many of the similar words in their domain, such as amuldistributor.com, amulboard.com, amulfran, many kind, amuldistribution.com, kind it. As a part of their scam, what has happened? They made bogus bank accounts using Amul name, sent fake forms via emails through Amul, asked for payment to become an Amul distributor and franchisee store, ran recruitment scams, everything they did in place of Amul. But later on, Amul won the case, and all these gradually vanishes away because Amul was a vigilant watchdog, and they really found that some companies are running using their small like words of the and using in their domain. That's why Amul sued them and later on won all cases because that was a big brand. So it's very important sometimes that when the company has launched their own domain name, because after that they can sue for every company who is using their own domain. But before that, if somebody is there, like in the case of Nishan couldn't use their own domain. Why? Because already Nishan Computer was existing. So this is the scenario. So how to protect the trademark from using by others? So in such cases, there is a like a particular body that is, we can find all the domain names through WHOIS information, through which we can find out who are the similar domain names to us. And if we really find, we can really follow a simple online procedures administered by WIPO, that is World Intellectual Property Organization, and the body is Domain Name Dispute Resolution Board. So through which independent experts decides which domain name should be returned to you or to be cancelled. So yes, there is a proper dispute resolution board, and that takes care of everything in case of domain name dispute. So there are many bodies like this, but what is important is like we have to select a domain name very wisely. We have to register our domain name and check it regularly. Is there any similar one going on, or we are protected? Then we have to protect our domain name and trademark, making sure that nobody else can use them as their domain. And if required, we have to use all available legal means to get the domain name transferred to you or cancelled. Suppose somebody else is using, it should be transferred to us or it should be cancelled. Otherwise, it will definitely reduce our own revenue, or we might lose our reputation in course of time. And also we have to do the IP audit of our website. Whenever we make a website, what is important is like we have to use the content that should be the point words. We shouldn't use anything which is already available, because everything available on net are not copyright free. We may fall prey of some copyright case. Then we have to control access to specific part of our website by encryption, online agreements, or conditional access system. So through which we can protect our website from getting infringed. Somebody might take random parts of our text, may get infringed, may infringe our website. So in such cases, we have to use the proper channels to find out that our domain name must not be used. And if we are using some technical tools for making our own website, we have to take a license. First of all, we cannot use any technical tool as such to make our own website. We have to take the license or proper agreements, then only we can use such technical tools also to avoid the infringements or avoid any kind of violations. In terms of patents, why? Because this is very important. Patent is a tool for our product enhancement. Whenever we have a patent right, it simply says that our product is novel, unique, useful, industrially applicable, and non-obvious. So it's definitely you can say that definitely a mark of our own genuinity and our own innovativeness. So once we have a patent right, our product value suddenly goes very high. So revenue generation itself become very easy, because people trust us. Even we can scale up technology transfer, commercialization is much easy with a patent rights. But important is like how to manage our intellectual property. So for any enterprise, any business, IP management is an essential tool. Why? Because there are many ways by which it could be infringed. So direct infringement or indirect infringement, both could be done. Direct means through literal words, any component, any process could be infringed. Equivalent products could be made to us doing the equivalence infringement. Somebody might be using some part of our product and inducing others to make the similar kind of total formulations, total products, compositions by inducing. So that is induced infringement. Or somebody else might be preparing like some part or contributing towards the infringement, means not the whole product, but some part without which my own product cannot be made. So if somebody else is producing that, so it's a kind of contributory infringement. So any kind of patent infringement might take place even after the grant of the patent. So once we acquire our patent right, we shouldn't sit as such. We should have a proper vigilance over what is going on inside the market, and is anybody is infringing our product, or if they are infringing, definitely we should sue them, because it's a kind of violation of IP rights, and also our revenue generation will be lesser as compared to others, because others are also producing parallel to me. So this is the scenario. So how to search it? Exactly, we have to search for patentability search. There are many kind of patent search which are very important tool to avoid the infringement. What is important is like we shouldn't infringe others. Others must not infringe our product. And this could only be possible if we go for a proper patent search. So validity search, we should check like others patent, if they are really violating our or infringing our own product, then are they really valid? Their claims, are they valid, or they are just entered without any validity? We have to see how much part of our product is getting infringed, whether process or any component or all components, what is being copied. So we have to totally map our product with others' product to see And if they have a patent rights acquired after us, definitely it's our rights, because we have launched our product earlier to them, we have entered the market, we have the patent granted earlier to them, so rights goes with us first. Freedom to operate search is must. If suppose somebody is suing us for infringement, we have to see what are the legal boundaries, like which are really taken up by the patentee or the innovative products. So what is the part which are free to be operated, and what are the parts under which, suppose if I am operating, I will not be considered as infringing some other's product. So freedom to operate search has to be done. State of the art search is important, what is actually in the market and how we are different. So if we are like focusing more on exactly we shouldn't infringe, why? Because if somebody is saying that yes you are infringing, but I have to prove no I'm not, why? Because I have some portions which are very different to you, and these portions only I'm doing, that is not linked to you. So in such cases we should avoid any kind of litigation against ourselves, and very plain thing is that we shouldn't infringe others product intentionally. So this part is important. The Indian government, what is important in Indian Patent Office is like every patentee who has a like a granted patent in their hands, they must file the form number 27. So what is form 27? This is a statement of working of patents in India. They have to time to time submit a report that invention has been worked in terms of, yes, for the granted invention I'm manufacturing the product in substantial amount and making it affordable to the people of India. Public requirements are met because I'm producing a large amount, and I'm fulfilling the needs of the people. And I'm also giving employment to the people of India. Why? Because I'm manufacturing more in India. So this is the purpose of the Indian government. Like once a patent is granted, they must not go in vain. They must solve the problem of making it available at a reasonable cost, and also they must be manufactured in India. Make in India initiative should be promoted. It's important. But suppose somebody has taken a patent right and sitting with the patent right without manufacturing, or somewhere manufacturing but not in India, somewhere else, some in other country, so it is said to be not working. And in such cases, the patent rights are not considered to be valid, and in such case government may intervene and say you to give a compulsory license to some other company who is manufacturing the product or who can manufacture the product in India, and yeah, to make it available at a reasonable price. So this is important. Like even the government doesn't want that every grantee must is sitting with the patent right. Patent licensing, that I have just said, licensing is renting of IP. This could be voluntarily or not voluntarily. Suppose an innovator, which is a student innovator or a faculty innovator, academician, who is like inventing something, but after inventing, what they have a patent rights granted, but then what to do? They can license this particular formula, this composition, to some company who can manufacture the product, and in return they can gain a large amount of royalty. So this is a kind of entrepreneurship where uh, not only it's not very possible for every innovator to establish their own firm, but this is a kind of IP licensing through which IP commercialization takes place. So suppose if I have a patent right granted, I can give this formula, this composition, this product, full formulation, full process to some other company, and in return I'm getting paid back. So these royalties are a very lump sum as a unit sold or as a lump sum. This is very attractive, especially for innovators, and this is a major way of IP licensing. But suppose I'm a firm already and have been granted a patent, but I'm not able to manufacture in India because of many reasons, and suppose for 3 years I have not done it. So in such cases, government may intervene, and after intervening, government may say that yes, you give your formula to other company, and other company will manufacture. Sometime I don't want this to be done because this is my own patent rights, and yes, royalties or licensing royalties are not much as compared to when I already manufacture it. So in such cases, government may intervene and they may say to give the license to another, because government is not satisfied with my form number 27. They are not satisfied with my working. So in such cases, this compulsory license may happen. Another option is cross licensing, means we are exchanging the IP. I have the IP rights with me, but I'm not very keen to produce in India, or I don't have the facility. I don't have so much revenue to start my manufacturing. Other company has IP rights of some other component which suits me. So in such case, suppose I want to manufacture something, but I don't have the patent rights. Some other company has. We can exchange the patent rights. So that is cross licensing. In such cases, I can transfer my IP right to some other company. Some other company will manufacture my product, and I will take back their patent rights of some other component, some other product, and I will manufacture that product. So suppose it suits me. I have the patent right, but the other product suits me more. So in such cases, cross licensing could be done. So it's a kind of collaboration without any risk of litigation, and there is no financial exchange between the parties. It's the exchange of IP rights. So suppose I am selling some kind of textiles, another has some food product patent. So we are exchanging, and now I'm producing food products, another is producing textiles. So this is another way of way of monetization of IP rights. So patent licensing is a very important part. I will happy to answer some questions, because this will be more important. So, okay. So, yeah. Khadim Shadi, is there any duration limit for trademark rights? Okay. So, yeah. Duration limit is for 5 years. Suppose for 5 years, if you are not using your trademark, or your trademark is not visible on your products, so in such cases, it may happen that you have to surrender the trademarks. That is important. So for 5 years. For patent, it's 3 years. For 3 years, you have to manufacture in substantial quantities. Otherwise, you have to license it. Government may also intervene for licensing it. Okay, Jiva Balu, kindly highlight on domain registration procedures and website to register. Okay, so domain registration or website to register should be done by a proper license, licensing software systems or technical tools. I just said you there are many websites which are offering it free, but there are certain terms and conditions, we have to follow them, or it could be paid websites. So it should be totally license based, domain registrations and website or domain. What is important here is like your domain must not match some other domain that is already in existence, or once you prepare your own domain name, make it a very quaint term so that it must not match with other, and others also may not take it later. And once you register your domain name, be your own watchdog, that you have to see like others must not take up your own domain name in later course of action. So that is important. A trademark duration is 10 years. After every 10 years, it has to be renewed. But 5 years is the time, if you're not using it for 5 years, it's mismanagement of IP right. I can say that. And then government may intervene. You may need to surrender your trademark to some other company, because many companies might be very interested to use your own trademark. Suppose if you're not using and sitting with just taking up the trademark, that is not good. That's why. So, Alka Saxena, we are from school. Students have filed patents which are commercially viable. Yes, definitely. Every student, whether it's a school or a college or a university or a researcher or a PhD student, must file at least the provisional patent once they have an idea in their mind. And within 12 months, they have to complete their product and file the complete specification with the claims. And later on, after filing the complete specification, they can get it published on the site of patent office, and they can get it examined also. After that, it could be granted. So, and yes, I just told you there is a 80% reduction in the fees. So everyone should leverage the opportunity of filing a patent application at a reduced fee of, because it's just a 1600 through e-filing. So every even school student can afford it for a provisional filing. So, what is the Jiva Babu? What is the frequency of submitting Form 27? Is it every year? Yeah, for the first 3 years, actually, after getting the patent right, for the first 3 years, you have to show that I'm manufacturing. So if for the first 3 years, normally at the expiry of before 3 years, you have to submit the first form 27. Later on, you have to submit it on yearly basis. D. Paramsimam K. Can we license before the grant of filed patents? No. After grant only, it's suppose that you have the patent rights in your hands, and then only you can license. Because granted patent can only be talked about the licensing. Nobody will believe you unless until you have a granted patent in your hands. That's why that's the scenario. So if any other question, I will be happy to answer. Okay, Professor KP Kadalkar. When a product is licensed, who is supposed to keep a watch on infringement? Licensor or licensee? Suppose a product is licensed. So suppose you are licensing to somebody else. Now the other one is manufacturing, and the revenue goes to them actually. So if somebody is infringing, it's like important that one who has the license currently, they should have a watchdog, because you are just getting the royalty in return because you have already licensed it, and your royalty will be almost the fix, and you are getting it on regular basis whatever you choose. But those who are actually manufacturing will be in threat, because their revenue will go down if somebody else is infringing and preparing or manufacturing or selling the same kind of product. So it's not like affecting you much, but the person who has the license currently. Okay, Dr. Shwam Prakash Patel, what are the best ways to identify if somebody is infringing our granted patent? Patent search. Once you go for a patent search, because unless until something is in public domain, you can't see it, because on websites only after publication of patent, they are on the sites. So that is about the patents who are infringing. But somebody suppose has not the patent rights, but still they are infringing your products. Then only thing is that you can have the Google alerts, you can have the technical tools. If you are visiting shops or malls, you should have a quick watch on what is exactly in market. Is it similar to you? Are they using the same kind of composition that you have patented, or same kind of trademark that you have registered? Is there any text that you have copyrighted it and they are using on their labels? So everything you have to take in account. So in every company, there is a proper legal section who looks after all such kind of infringements. And if infringement is taking place, definitely legal action can be taken. And all the patentee normally wins the case because infringement is totally illegal. So in this way, yes. Dr. SRM Krishna, after patent publication happened, what is the best approach to get the grant? Can you? Okay. So once you file a provisional, within 12 months, you have to file the complete specification with claims. From filing, after 18 months, suppose you have filed today, after 18 months, it will be published on the site of Patent Office and in the Journal of Patent Office. Suppose you want an expedited publication, you can fill the Form 9 with a fee of 2,500, and it will be published within a week or maximum 15 days. So after publication, you can request for examination to the patent office by filling the form 18, and with a fee of 4,000 through normal process and 8,000 rupees for expedited processing. So unless until you apply for examination, patent office will never examine your patent application. And after examination only, they can either grant the patent or reject the patent. So this is the process. Yes, examination request must be filed within 48 months from the date of first filing. So 4 years, within 4 years at least you have to get it examined, because after that it seems to be abandoned. Okay, Dr. D. Varalakshmi Shiram, is licensing legal in India? What are the laws associated with licensing? Yes, licensing is legal in India, and licensing is done based on the mutual basis. Like but it's said that legally minimum 10% of total cost must be given as a royalty. That is said, that is a minimum. But suppose if mutual consents are not okay between two parties, so in such case, even government can interfere. Suppose if I'm requesting the other company that give me license because you are not working perfectly in India, your products are not being available at a reasonable cost, you are not manufacturing a substantial amount, and I'm requesting for a license to you, but you're not giving me, or if you are giving me, you are asking for more royalties than required. So in such cases, I can connect to government, and government may intervene in giving me compulsory license. So in that case, that company has to give me compulsory license at a reasonable royalty. So yes, licensing is totally, and even like in many, suppose the case of Bayer versus Natco, that was a very important case where the two companies were not mutually agreeing on licensing, but then government interfered and taken up the license and given to other company forcibly. So this could also happen. Important is what government wants, that if you have a patent grant in your hand, you must utilize it. So that is the way. Either use it or you have to lose it. So if we are very happy after getting a patent granted, that's not actually the happiness. Happiness is there whenever we actually use the granted patent in manufacturing the product and bringing it in the market of India at an affordable cost and in substantial amount. So that really patents would be useful. So what's the purpose of giving the patent granted to innovators? The purpose is the manufacturing. So we should be ready to manufacture or to license it to some other company. That is the way through which we are also contributing. So other company will prepare the same product, and yes, they will prepare the product, and they will manufacture in substantial amount. And in this way also we are contributing towards the Make in India initiative. So yeah, so I'm really happy. I felt really happy to answer your questions. If you have any further question, you can definitely connect to me, and yeah, you can take my like you can have my email or LinkedIn ID. You can connect me for any further question if you have. So I think my time is up. Later on, if some more questions are there, I'll be happy to answer later on. So yeah, thank you very much.
Thank you so much, ma'am. Thank you, really, ma'am. Appreciate it. I think many of the audience here, they know you, and say maybe they already know your email and phone number, and it's great to hear from you all the time. And I think that trademark part, it was unique, so which we are discussing too much on patents. So great, ma'am. Thank you so much. Have a nice day. And with this, folks, I will introduce you to our next speaker. And that is Dr. Bijay Sahu. He's the head of Technology Innovation Support Center and IP Facilitation Center of NRDC. And he is going to speak on technology commercialization efforts by NRDC, the role of IP in technology transfer, and how you as academics can take the help of NRDC to commercialize your own inventions. So with this, I welcome Dr. Bijay Sahu to the live stream. Sir, welcome to Turnip Innovation Festival. Really our privilege to host you. And the stage is yours. You can interact with the session on the chat, and I'll highlight the comments as you move forward.
Thank you, Dr. Kapoor. I'm not Bijaya, I'm Dr. Bijay. Although in Odia, normally we write Bijaya. So thank you for giving this opportunity, and wishing you all a happy and prosperous New Year's, happy Pongal, Sankranti, Bihu, because there is a great diversity and unity of the country. And this is the collaboration where we all are participated and celebrating the Torn IP Innovation Festival. So this is also a festival, and this is also a journey of our innovation to mitigate the challenge of the nation towards self-reliance and indigenization. So thank you, Dr. Kapoor, and thank you for giving this opportunity. And in fact, the topic is quite relevant. Yesterday, let me also brief you that under Make in India, to fulfill the dream of Prime Minister towards indigenization. Yesterday, we transfer and commercialize 3 technology. That technology was developed by our scientists, and it was patented, because patent is a strategy, IP is a strategy to create the value and also extract the value of the benefit sharing as a creator of that IP. So my topic is what is the role of IP in technology transfer, and I will share some of the example, some of the case studies, some of the challenges, some of the opportunity for us, how we are making the difference in technology transfer, providing technology from bedside to the bedside, technology at lab to the land, technology at mind to the market. So let me just share my presentation. And anyone have any query, any question, you can drop the message and to me, so that rather than we should have a one-way talk, we should let's have a deliberation, discussion, and also co-creation in the innovation journey in celebrating the Torn IP Innovation Festival. Dr. Kapoor, my PPT is visible to you all?
Yes,
Okay.
yes, it's visible.
Okay, thank you. So already Dr. Kapoor had informed about our recognition, our role, our reach out, and this is the program where we have to connect the dot, particularly when we are talking about technology, technology transfer, and what are the issues of IP. So until unless we own, we can't give it. So ownership is most important, and that's the role of IP in technology transfer. And that's the role of NRDC in sharing the benefit of innovator and industry, and making them, mitigating them, and also managing their in IP, and also catalyzing that IP. Friends, being a citizen of India, we must have to celebrate the innovation at each level. And today we have to celebrate the innovation at national level. And India is certainly making difference from 81 rank global innovation index to 40 ranks today. In 7 years, we are continuously shaping our goal, mitigating the challenge of the people reached to unreached. That's we have created today. And now we are 40, and certainly we will go to second digit, because the startup India, the make in India, the digital India, now we have a self-reliance India that has already created a momentum. And it is the momentum of Torn IP also in celebrating the innovation. So I will certainly discuss about already the time is less for me. So IPR is what biggest challenge, because as I told, until unless we own, we can't give it. So ownership is important for all the thing. As far as our research commercialization is concerned, research for development is concerned, access to plant genomic research. India is the 12th mega diverse country in the world. The issues of IPR is very, very paramount. We have seen in the case of Haldi, Neem, and Basmati. We have to see the India challenges at a bilateral and multilateral level. We have seen in the case of Indo-US S&T collaboration, particularly the issues of Special 301 provision before India, as far as the US Department of Commerce is concerned. And invention innovations comes from various geographical location. So the ownership is important. The owner must be recognized, rewards, and also owner must be rewarded over his creativity and invention. That is the principle, basic principle of discovery and invention today. We have to recognize to the innovator. Access to technology, our dependency on import of technology is very high. Until unless we have our ownership, we can't fulfill uh, the objective of self-reliance. Issues of the collaboration related to how we are collaborating with various institutions, industries, MSME, startup, corporate, how we are signing the memorandum of agreement, memorandum of understanding. We must have to understand the legal clauses, liability, redress, and these are the IPR challenges today in the ecosystem, where that ecosystem is knowledge intensive. When we talked about R&D consultancy, no one gave you the money free of cost. there should be the liability and there should be a responsibility. In that respect, we have program of various department, government, corporate, like research funding program for contract research, collaborative research, grant-in-aid research, sponsored research. The IPR is important because somebody is giving money. What are the benefit sharing? Why somebody is funding for that? We have to look into that. And these are the IPR challenges. These are the IPR issues as far as the research commercialization, technology transfer, or technology IP monetization are concerned. We have seen this pandemic, the great change, challenges, and also in that challenges, we mitigated that challenges and also created an opportunity of livelihood. Every challenge, there is an opportunity, and necessity is mother of invention. We have seen how Covaxin, Covishield played an important role in our day-to-day livelihood. We have seen many technology in tracing, testing, and treating of COVID-19. And that is the creativity and innovation of our in this ecosystem where people have created and also translated, and people of the society are mitigating the challenge. And that innovation is nothing but the IP creation. We have seen during COVID also the medicine like 2DG drug developed by DRDO, and that was given license for commercializing to DRDO, the Dr. Reddy Laboratories. At that time, there was a ray of hope to every human being, and that invention created an impact, and that innovation created a opportunity of livelihood. And in that, the role of inventor, innovator, and also the role of IP creator played an important role. So IPR is nothing but the creativity and invention, and typically in Indian ecosystem where we believe IP is nothing but a knowledge, and knowledge must be acknowledged. And the Ganesh Saraswati is the nothing but the IP where we are creating at our academia, and we have to leverage that knowledge into a process and product so that we can connect to Lakshmi, and we need to bring Lakshmi and Saraswati, and we have to respect the IP, leverage the IP, manage the IP, and also monetize the IP. Then only we can mitigate the challenge, and also mitigate the challenge towards sustainable development goal, and also the basic objective of today in India towards self-reliance on technology. So far as the intellectual property, why IP is important? When we talked about IP, there are various type of IP that we know. Every IP plays a important role in their objective with their connotation. So any invention, when we talked about, certainly there is a issues of patent, and patent is nothing but an invention. That invention have a industrial applicability and also inventiveness and novelty. So having patent is nothing but the recognition of an institution, recognition of an individual in the ecosystem of innovation, so that someone has created. The way we recognize the innovation in various sector, whatever that is coming to the market. So IP, that patents, for that somebody will come and trust and believe and invest, and in that the liability is there. IP gives the opportunity of confident for an investor to invest, and in that we got the opportunity of technology transfer. So IP is nothing but creating value and extracting value and benefit sharing. The invention related to the which in my presentation you can see process for the production of lutein from marine chlorophycin algae. Scientist who is standing right to me, the investor, the industry leader who is standing left to me, and we are doing a technology transfer, and that was developed by one of the national institution called National Institute of Ocean Technology. The patent was filed, protected, so that the invention has the originality, and there will be no issues of infringement, because today infringement is the biggest challenge in the knowledge intensive sector. So this is invention that create value, connect the dot, mitigate the challenge of the society, and giving hope to the people of the society in getting an indigenous technology. We have seen during COVID, and there is a best example of NRDC role on Navarakshaks PPE kits. that was developed from a defense ecosystem and mitigate the challenge of the societal challenge. And that was developed by a scientist, doctor scientist at Indian Navy, and NRDC protect, manage, and also commercialize this technology know-how to as many as 10 to 12 MSME in the country. And the technology or the Navarakshak PPE kit is very, very affordable, breathable, and also comfortable. This is innovation that create value and also create the opportunity of livelihood. Friends, when we talked about innovation, certainly we must have to revisit the Indian Bollywood movie Three Idiots. It has a great notion, it has a great thought, it has a great movie also as far as a viewer. So in that, the Funsung Wangdu, Chatur Ramalingam, the character itself shows how we have to be innovative in the changing paradigm of ecosystem innovation. At the same time, how we must recognize and respect to the innovator, inventor, and their ownership of IP. We have seen the challenges and the debatable issue at that time between Bidhu Vinod Chopra and Chetan Bhagat. So innovation is always market driven, invention driven, and technology driven. And innovation create the value, and we must have to look into it so that we can create the value for the society and people and solve a valid problem of the society. And we must see the potential of that invention, and then we go for filing a IP or protecting it so that we can have a opportunity of collaboration with industries. So benefiting society and the economy, academic technology transfer plays a very important role in many countries like in US. The invention come from academic institution that has been validated, protected, managed, and also licensed for to many industries for the new process and product, and many more startup comes. And this is a AOTM report I thought I should share with you. And you can see how academic technology transfer plays an important role in the ecosystem of innovation today. So innovation is a long-term health of economy, and we need a healthy root system, and our healthy root system is academia, where the creativity, invention, IP, all this come, and we need to strengthen that. And in that, we can create IP, and that IP should be accessible to all, available to all, and adaptable to all. And we need to integrate IP into our research and development, and that must integrate with the monetization. Then only we can create the value and extract the value. We need to integrate IP into our institution, human resource, marketing, strategy, finance, in all sectors that will create value, goodwill gesture, brand positioning, merger acquisition, capacity building for the human resource, because every human resource is ornament to the institution, and they have a capability, and we have to see their inner strength. And in that, we can go for the IP monetization and securitization. Now I will come to our aspect, the NRDC, how we create the impact, how we connect the dot, how we help to inventor, innovator in the country in managing their IP, supporting for the IP, and also commercializing their IP. You can see the Defense Expo logo. In the recent time, Government of India organized Def Expo 2020 at Gandhinagar. The logo itself is a brand, and that is a trademark, and that brand we protected and managed, and this brand become a very appeal to the every citizen of India towards innovation activities in the defense sector. Recently, Army registered intellectual property of new combat uniform. That means no one should infringe our intellectual property, and in that way we can protect in the various form of IP so that we can create the value. The biggest challenge today is more fake drugs on sale in various parts of India. So institutional intellectual property policy is very important, because academics, lot of IP are coming, so that there will be a benefit sharing between inventor and innovator and also industry when there is a technology transfer and commercialization. And also the right, because intellectual property is a legal right, and there is a great opportunity for sponsored research, collaborative research, contract research, and grant-funded research. And in that, we can create the value and also create the impact and also create more IP, and that IP has a role to the industry in coming out the new product, and that new product is the nothing but the indigenized product for the nation. So there should be a benefit sharing of this commercialization of IP, because that IP itself decide the ownership, benefit sharing, liability redress, so that inventor must be recognized not only in terms of academically or promotion, he must get the royalty or the sharing of fees, licensing fees, and that we do, and that we have been creating the impact to various institution and R&D organization today. When we are transferring any technology, when we get the premia, that premia also we shared, and also the royalty also we every year we collect and share the royalty to the inventor. That's the role of IP in mitigating the challenge. So issues of intellectual property monetization today, we have to understand technology landscape, what are the demand. Based on that demand, we have to mitigate such kind of challenges, prioritize the innovation with potential, determine the value of intellectual property, and choose intellectual property monetization strategy. And we have to create a approach of IP monetization holistically. So we have to extract the value through technology transfer, and that is the way we transfer the technology based on the intellectual property. And many times we failed, and we did not get a appropriate customer when there is no IP protection, and that's today we need, and we realize that IP protection is must as far as the technology transfer is concerned. So NRDC is a national organization under Ministry of Science and Technology. It is a 70-year-old organization, and you can see some of the very indigenous product that has been commercialized today. It connects academia to industry and create a linkage in development, promotion, and commercialization of technology emanating from R&D institution. It is ISO 9001 2015 company, public sector organization, and we have so far licensed more than 5,000 technologies, supported many IP, given many national awards, budding innovation awards, societal innovation award, technology innovation awards, created many institutional ecosystem of IP protection like Intellectual Property Facilitation Center, our reach NRDC outreach center to reach out to each corner of the nation, so that people of the nation will get benefit. And we have as many as 2,500 technology available for commercialization, and I will say more than 2,000 are green technology, and it has a great impact towards sustainable development goal. And that's the effort we are doing in the country in transferring the technology from lab to the land, mine to the market, in doing all kind of value addition, not only IP protection, validation, technology development support, intellectual property protection, evaluation, field testing, market survey is most important, feasibility, and also providing incubation services, so that we can come out the product innovation in protecting from IP to commercial technology readiness level, and also create an opportunity of investment readiness level. So TRL to IRL to business readiness level, BRL, and we have been working on that. And also licensing technology, collecting the royalty, sharing the benefit of the inventor in the commercialization of technology. And we have done more than 5,000 technology we have licensed in the country. We are taking our Indian technology to global arena and demonstrating our technology at the global level. We're supporting to many countries in agro processing sector, food processing sector, and many more sector, and transferring the technology and mitigating the challenge of technology development as far as the technology readiness level, from technology value of depth to commercialization of value of depth. And now we are going to establish a TRL assessment ecosystem, and making and defining the innovation readiness level to the investments readiness level of the any invention that is come to the us, and making this technology available to the common people, so that we can transfer the technology and handhold and create impact and fulfill the dream of Mahatma Gandhi, self-reliance and indigenization. Thank you for giving this opportunity. God bless you all. Jai Hind. I will take few questions. Yeah, Dr. Kapoor, any question, any query?
Yes, let's see from here, from the chat on the right. Let's see how IP helps impacting the lives of elderly. Technology plays an important role in healthcare for licensing in India. Dr. Varalakshmi Siram. So, sir, can you understand this question? Then, otherwise we move on.
Dr. Sviralakshmi, I think you can talk to me, and Dr. Kapoor, you can share my mobile number.
Yeah,
And
yeah.
Madam question is maybe because he might not be able to connect to any of the institutional mechanism as far as her
Hmm.
IP is concerned. So we will talk to them, and we will do our best. So innovation not confined to the young men can only file the patent or commercialize the patent. Anyone. So see, if she has any kind of problem, certainly we will do our best.
Hmm. And sir, many institutes, since the audience is primarily academic audience, so almost all of them are like the IP commercialization. They have to somehow fulfill certain criteria is there from accreditation bodies. So but they have no idea how to go about it. So is there any like contact from NRDC or contact of some agencies where they can get this kind of support?
You are requested to kindly share my mobile number and email ID, and
Hmm.
for all from IP protection to IP commercialization, we will support.
Hmm. Okay.
Okay.
So
So
yeah, you heard it. I mean,
you can post my mobile number and email ID
yeah.
also you can give, so anyone can get back to us, and we will do our
Mhm.
best.
So what are
And
the common traits? Uh,
yeah,
yeah,
Dr. Kapoor, you tell me.
yeah. So what are the common traits of inventors and the nature of IP, let's say, in academic, say, which actually eventually succeed in some kind of licensing or transfer? So what
See,
they should keep in mind?
See, I will give one of the example of recycling of plastic waste to tile. This is one of the technology, I will say, developed by one of the scientists. And from recycling of plastic waste, it is a tile. It has
Hmm.
80 years of lifespan, and this technology we transfer to as many as 7 8 MSME and startup in the country. So this is innovation is nothing but fulfilling the goal of sustainable development goal. So this is one of the example that means how a innovator is getting a support of technology transfer. In that, IP is playing an important role, so that I can say proudly the name of the inventor or innovator, that's the ownership.
Hmm.
And I think that's there is a question from Mr. Deepankar Saha. I believe I answered his question.
Hmm. Yeah,
And there is a Sanjukta Banerjee, follow Dr. Bijay Kumar Sahu on LinkedIn. Okay, okay. Thank
yeah.
you.
That's from my team. Yeah.
Yeah, thank you, Sanjukta ji, for giving this information. And this is collaboration. No one achieve in silo without
That's the thing.
collaboration, and that's the Torn IP Innovation Festival we are
Yeah,
celebrating. So
yeah. That's the
we
thing.
have some strength. You have some strength. If we will collaborate each other, certainly we can make the difference.
Yeah, yeah. That's what also one question came, that what should we do? And the main thing is you should have some marketing abilities. The inventor
Exactly.
cannot just invent and
See, I will give. I think I should share. Sometimes one young chap came to us, and he wanted to establish a startup, and he has some idea. But I told, you have some idea, but this idea may not validate. Then I
mm,
proposed, we have some of the technology, innovative technology developed by our national laboratories, and it is patented, and it has a demand in the market. Then I told, these are the area you will get in this ecosystem, and there is a demand of this product because raw material is available in your place. You can make it. Now he is starting his own venture, giving a product to
mm,
the nation. That is innovation that
yes,
create the value. And I think there is a question from how much IPR from institute
yeah.
converted into commercial. Arunji,
Arun,
I am completely agree. But the patent or the IP what we are filing must not be academic IP. we must understand how we create the value. Don't think that only IP, once we transfer the technology, we will get the money. But there are various way of IP to quantify both qualitatively and quantitatively. But at the end of the day, if we are doing research, first you have to own it. And the history of our civilization discuss on that part also. Even if there is a infringement, there is a punishment. So even Ekalavya infringed the intellectual property of Guru Dronacharya. So point I wanted to inform you is that let's have a ownership, then only we can go. And we should make a strategy why we are protecting IP, not for the sake of filing a patent or IP, but if it has a commercial value, we go for filing a patent.
So is there any change in the institute? Like, do you feel that in last 5 years, there is a significant advancement in institutes coming with commercializable IP?
Yes, many of our IP, what we are commercializing, technology we are commercializing is IP protected. Because suppose one industry is coming, someone is ready to invest, he will ask patent, he will ask design. Because if there is any tomorrow, if you are taking my technology and there is no IP protection and somebody has already patented, and he can file an infringement suit against you. So because we are in a knowledge intensive sector and knowledge must be acknowledged, the creator, innovator must be recognized over their creativity and invention. That is the basic principle of our ecosystem where we are in, and we are WTO compliance country. We have compliance all the TRIPS regime. So innovator across the globe, wherever the invention are coming, must recognize and reward. Then only we can create a sustainable ecosystem of innovation.
Great.
There
There's
is a
one question on
Rajiv Patel. Why Indian patent grant in India in very no राजीव जी, हिंदुस्तान का पेटेंट सबसे जल्दी आजकल हो रहा है पेटेंट ग्रांट आपके लिए. आप मेरे से बात करिए, आपको मैं इंडियन पेटेंट इकोसिस्टम इज नाउ वेरी well established ecosystem, connecting ecosystem. Anytime you can talk to any controller. So transparent ecosystem. I am not agree with you, and I will talk to you.
Yeah, there's one from
Professor KP Kudalkar. Can an inventor license his product to more than one license? Yes, sir. It is a non-exclusive license. You can give n number of people, so that you can see there is a principle and there is also policy. If you have got a grant from government institution, you cannot give exclusive license to anyone. You should give non-exclusive so that you can determine the value. And Professor Kadalkar, I will talk to you and also discuss more on that part. There is a question from Dr. SRM Krishna. After patent publication happened, what is the best approach to get grant? Can you please explore? See, sir, patent ka dekho, Indian patent system has a expedite examination is also there, but Indian patent system has to protect, has to file. So if you file fast, you will get a priority. And the priority is nothing but, suppose you file the patent today and similar kind of invention tomorrow I am filing, that means you have the priority. You are the fast. So under that, you will be considered the fast inventor who filed the patent fast. And in that, when there will be a publication is nothing but that was published and showcased to the nation that this invention came from Dr. Krishna. Anyone can oppose or post-grant opposition can be filed, so that to give a valid reason to recognize you nationally, the patent office journals come out and publish it. So that is the thing, and you have to make that approach. The best practice of ultimately it will be the first examination report will come, and if you go for expedite examination, expedite publication, it will be goes for grant of patent application after APR. So that is the process, and very systematic process. If you have any doubt, you talk to us, and if you want to file any patent, you talk to us. We'll do our best in supporting you.
Dipankar Saha is saying totalitarian principles of innovation. Is it totalitarian? Patents are not totalitarian.
Uh, Dipankar ji, I am not a sociologist, but I have a social kind of bend mindset people. So I will not talk on that part because I am a IP practitioner in my day-to-day life. We are supporting many inventor, innovator, MSME, startup, academia, industry across the country. Whoever comes to us, we are giving our handhold support. So we are part of the ecosystem of governance. So in that respect, we will discuss bilaterally, and you can talk to me anytime.
Yeah, yeah. Great. At least 200 people are still here.
Anyone have any? Because post lunch session, I just came. There was a meeting only. From there, I am coming to us for this event. But I will certainly request you. But Dr. Kapoor will Rahul Kapoor
Yeah.
share mobile number, email ID.
Yes.
Anyone have any doubt, any support? We are
Yeah.
national organization of Government of India under Ministry of Science and Technology. You are
Yeah.
requested to talk to us, discuss with us. We will support, handhold. This is our organization and it is a national organization.
Yeah.
राजीव जी का एक क्वेश्चन आया, हाउ कैन द रिस्क ऑफ कमर्शियलाइजेशन बी रिड्यूस? सर, जिंदगी तो एक रिस्क है, तो एवरी देयर इज ए रिस्क, देयर इज ए चैलेंज, वी हैव टू मिटिगेट दैट चैलेंज इन ए ड्यू diligently.
Yeah. Sir, post event email, we can send this detail, that at least some email ID or something.
Yeah, I
the
stopped my
participants.
presentation. I thought I should have a back. I need as many as question whoever. So
Yeah.
please,
Yeah, this is a golden time because someone from NRDC is actually right in front of.
Miss Huma Khan is asking my mobile number and contact address. Dr. Rahul, you can type or I can type here. There is no place for me.
I can give it in much faster way. Yeah.
हाँ, दे दीजिए सर आप.
So live chat में everyone has the number.
Yeah, my mobile number is 9810104163. Please give my email ID.
bksahu@nrdc.in.
Yes, yes. Thank you, Arun ji. Thank you, Huma. You can drop an email, and otherwise you can also speak to me.
Yeah, this how can risk of ये हो गया है. All right. Yeah. So when we are speaking, actually there's 45-second lag, 30 to 45-second lag before it goes to the live chat. But I think that people are also had a very long session, long day. So thank you very much. A lot of thank you messages are coming.
Thank you, Dr. Bijay Kumar.
Amazing.
That credit goes to Mr. Dr. Rahul Kapoor for giving this opportunity, and because of him, I came from a meeting to join with you all. So
Sir,
I am equally grateful to all of you for giving this opportunity.
So
Thank
we
you
are
all.
grateful someone from NRDC is here for this IPA commercialization theme that we have. Great, sir. Thank you so much. Really wish you a good day, and we will be in touch. And this is a small ecosystem, so we are going.
We have to connect.
Great. Thank you, sir.
Thank you. Thank you, Dr. Amit.
So with this, I will conclude Turnip Innovation Festival 2023. I am really grateful to everybody who's registered for this event. 221 I can see is the current people who are there on the live stream. Many of the audience has been rolling. So in the morning we had like up to 360 people who attended Turnip Innovation Festival. So I am really grateful to all of you, and I hope that you have taken some inspiration, some important notes, and some important learnings from this online conference. I can see a lot of thank you messages. So that's great. So you will receive a feedback form after the event is over. So around 4:30 p.m. or maybe since we have to send thousands of emails, it might take a while, maybe a few hours it might take for the email to reach you. But make sure that you fill the feedback form with your verified and registered email ID. Only then you will receive the event certificate. And if you have not verified your email, make sure that you fetch the verification email that is sent after you have registered for the event. It can somehow go to your spam folder or the promotions folder. So please fetch the email from there and click on the verification link. Only then your email is verified and it is there in our system that you have registered and verified your email. So before filling the feedback form, make sure your email is registered and verified, and only use that email ID to avail the feedback form. So I'm really sorry, but if you do not verify your email, we cannot issue the feedback. We cannot issue the certificate to you. So thank you everybody. I'm really humbled by so many thank you messages that is coming. So Nitya, Periam, Sami, Manan, Alina, Mrs. Dokate, Divya, Niranjani, Lata, Palvinder Kaur, Vihasini, Pradap, incredible. Dipankar Saha, Arvind, Khadem, Surender, Pradap. Thank you so much. Thank you, everybody. I urge you to go to turnip.co.in. That's our website. There are various free courses that you can do on basics of intellectual property. And there are also some low-cost patent courses that you can do from our website. So please check out the links in the description of this YouTube video. Check out turnip.co.in, our website, if you want to do any courses. And by all means, if you have any feedback, you can also reply to our course emails. You can also fill the feedback form, whatever suggestions you have for improvement or any feedback you have. Please feel free to reply to course emails, feedback form emails, or the feedback form itself. Thank you. With this, I conclude Turnip Innovation Festival 2023, and I will see you in other Turnip courses and events. Goodbye and have a great weekend. Bye-bye.